I gotta see if the museum is having a sale.
Oh, God. The museum?
I just watched. Is that what you said?
Come on, Tom. I think it's going to be the first couple days. Are you here that one?
Please rise. The Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear ye. All persons having business with the Appellate Division, draw near, give your attendance, and shall be heard. Be seated.
Good afternoon and welcome to the Appellate Division. I'm about to call the calendar and I'm going to ask you to request the time that you need for oral argument today. I'm going to ask you to please be considerate of what you actually need rather than what you previously requested, because right now we have over 7 hours of argument that's been requested. The first case on the calendar is People versus Tyrone Nelson. 7, 2, and 7. Oops. Williams versus Beth Israel Medical. And do we have a respondent? Do you want to, since we don't have a respondent, would you care to submit, or do you want oral argument?
We would submit, Your Honor, if there's no response.
Okay, we'll mark it submitted. Thank you. DC Children is submitted. Barretto versus Groat Street Apartments. 5, 2, and 5. Thank you. Dennison versus 300 East 57th Street. All right, we'll give 5 and 2 to the appellant, 5 to the respondent. Rodriguez versus 3rd Avenue Transit. I can give you 1 minute. I can give you 2 minutes. Okay. 2 minutes and 0. Morera versus Morera, that's submitted. People versus Jose Delgado, that's submitted. Tiny One versus Samfet Marble.
Appellant requests 10 and 2. Respondent requests 7 minutes.
7, 2, and 7, thank you. Foster versus Kassab.
Appellant requests 7 and 2, Your Honor.
Do we have a respondent? Yeah, and I'm sorry, how many do you request? 7? 7, 2, and 7. People versus David Woods. 6, 2, and 6. People versus Nicholas Button. It's submitted. Sands Brothers versus Metropolitan Paper.
Appellant requests 8 and 3, Your Honor.
Respondent requests 4, Your Honor.
6, 2, and 4. Coleman versus Kirby. Submitted. 14 East 4th versus Toporek.
Appellant requests 5 and 3. Good afternoon, respondent requests 5.
5, 3, and 5. Mateo versus Ionelli Construction. 5 and 2. 5, 2, and 5. Thank you, gentlemen. People versus Sidney Monk. Submitted. Hamill versus Park Avenue Armory.
Appellant requesting 7 and 2, please. Plaintiff respondent 5.
5, 2, and 5. Thank you. 5, 2, 5, 3. Did both respondents submit separate briefs? You did. Okay. 5, 2, 5, 3. Just checking. People versus Gilbert Nunez. Submitted. People v. Maria Esperanza. 7, 2, and 6. Ream Contracting versus Altschul and Altschul. Submitted. First case on the calendar is People versus Tyrone Nelson. Please step up.
Your Honors, I would like to introduce Samantha Bosolovich, who's an attorney admitted in good standing in the state of Louisiana, and request that she be permitted to appear pro hac vice.
Okay. I'll allow it. Thank you. You may proceed.
Your Honors, may it please the Court, Samantha Bosolovich, in association with the Office of the Appellate Defender, on behalf of Mr. Tyrone Nelson. Mr. Nelson was deprived of a fair trial when the judge did not recognize uncharged crimes evidence as Molyneux, and then admitted extensive Molyneux evidence of domestic violence and a threat to kill. The
evidence of the uncharged crimes was crimes that had occurred within hours of the crime that was being tried, correct?
Correct, but at trial, the prosecutor answered the question put to him of whether this was an uncharged crime when referencing the domestic violence allegations, saying yes, because it was a separate uncharged crime that was unrelated to the charged crime at issue at trial.
Right, well, there's not a blanket prohibition against that evidence. It's just, it comes in, it could come in for other than a propensity purpose, correct?
Correct, but
And was
here,
the jury given a limiting instruction regarding the use of that evidence?
the jury was given a limiting instruction for part of the evidence. For the domestic violence, there was a limiting instruction for the witness's testimony, but there was no limiting instruction for the Molyneux evidence of the threat to kill, and there was no limiting instruction for the 911 call, which contained evidence of both the threat to kill and the domestic violence. And with respect to the domestic violence, it was the most prejudicial of that evidence, as it stated as a conclusive fact that Mr. Nelson had already hit his girlfriend several times. Even though there was a limiting instruction for some of the domestic violence testimony, the limiting instruction was not enough to cure the prejudice against Mr. Nelson because it should not have been admitted in the first place.
But counsel, didn't it complete the narrative as to what was happening, the events as to why these two people were interacting with each other at that point?
The court did find that it was under the completing the narrative exception, but that exception is only applicable when it is necessary to complete the narrative. And the court has explained that it is only necessary when without it, jurors would wander helplessly trying to sort out ambiguous but material facts. Here, there was obvious alternatives that could have completed the narrative that would not have been highly prejudicial to Mr. Nelson. As defense counsel proposed, the witnesses could have testified to hearing a heated argument between Mr. Nelson and his girlfriend. There was no need to elicit the testimony of slapping noises, hearing her say over and over again, "Stop hitting me," describing that as a sound of someone in anguish. That went far beyond what was needed to give context.
Couldn't that also go to the defendant's state of mind, to sort of really to explain what was happening in the apartment at that time?
That is not the reason the court admitted the evidence, and it wasn't what was given as the rationale the jury could use it for in the limiting instruction that was given. And it was not relevant to the motive of Mr. Nelson. It didn't go to the incident of the charged crime was unrelated to the domestic violence allegations, and it was relevant to know that there was some argument going on because that's what initiated the events between Mr. Nelson and the complainant. But again, that could have sufficiently been explained by just saying there was an argument, it got heated. There was no need to elicit the testimony of slapping, of hearing her say in anguish, "Stop hitting me." And in the 911 call, it said he has already hit his girlfriend several times. And in the 911 call specifically, it wasn't needed to give context at all. It could have easily been redacted and not confused to the jury, as defense counsel requested.
Would harmless error analysis apply to the parts, admittedly, of the call that shouldn't have gone in?
I'm sorry, I didn't hear the last
Would
part.
harmless error apply to parts of the call that should not have gone in? Would harmless error analysis apply?
Yes, this was the only evidence that actually stated as a matter of fact that Mr. Nelson hit his girlfriend, and it said he hit her several times. We know that the jury relied on this evidence and considered it because they specifically asked to hear the 911 call replayed and to hear the complainant's testimony reread to them, specifically starting from the portions where he described hearing the slapping noises. And again, this case was a close case. There were only 2 days of evidence presented to the jury, but they deliberated for 4 full days, and they sent out 13 notes, one of which was to inform the court that they were deadlocked on all charges, and eventually they did deadlock on the top 2 charges, which the judge ultimately accepted because he had found that they really had done their due diligence in trying to get to determination and had extensively looked over all of the evidence, and a lot of that evidence was this Molyneux evidence. It comprised a significant portion of the record. They considered it during their jury deliberations, so there's a reasonable inference that had this Molyneux evidence not been admitted, they could have hung on all charges or even acquitted Mr. Nelson. The Court of Appeals in the Green case has said specifically that where a case is close and the jury deadlocked, there's an inescapable inference that the jury gave some probative weight to the Molyneux evidence. And here we don't just have the inescapable inference, we have the actual notes from the jury asking to hear it again and again. For these reasons and the reasons set forth in our brief, we ask that this court reverse Mr. Nelson's conviction, and we rely on our brief brief unless there are any further questions.
Thank you. You may proceed.
May it please the court, Amanda Regan on behalf of the people. The trial court's evidentiary rulings were entirely proper. Here, the court properly exercised its discretion when it admitted evidence that just a few hours prior to the stabbing, defendant had threatened to kill his nephew, and that immediately prior to the stabbing, Fearon and Phillips heard what they believed to be the sound of defendant slapping his female guest. Our argument is not that this is not Molyneux evidence because they were not uncharged criminal acts. Our argument is that they were not separately charged criminal acts. They were all part of the instant crime, and that's exactly what the judge found when he held that this was admissible to complete the narrative. And there's numerous cases which we cite to in our brief that support the position that when evidence is admitted to complete the narrative, this sort of Molyneux type evidence is properly permitted.
Why were the acts of domestic violence purportedly between the defendant and his girlfriend? Why was that part of this charged crime involving different victims?
So, first of all, there's no affirmative evidence that the defendant actually assaulted anybody besides the victim that he stabbed. There's no evidence that they saw him hitting the woman that was in his room or
But they
anything like
heard
that.
it. They heard slaps.
Yes, and
So it's circumstantial evidence of domestic violence, isn't it?
yes, and what they heard prompted them to believe that the victim, the female guest was being victimized by the defendant, and they went out there to stop him. And immediately after Mr. Fearon says, chill out, stop what you're doing, defendant says, I'm going to show you, and goes to get a knife from the kitchen. Mr. Phillips sees him heading towards the kitchen. He hears him rummaging in the drawer where they store the only long serrated bread knife in the apartment, and immediately comes back to the bedroom and tells.
So your claim is basically that, to complete the narrative, that it precipitated the assault by the defendant against the victims in this case.
Absolutely. Presumably, had Mr. Fearon not attempted to intervene on the woman's behalf, defendant wouldn't have ever retrieved the knife and stabbed him. And any prejudice to the defendant was eliminated by the court's limiting instruction. First of all, defendant.
Well, do you agree with your opposing counsel that the limiting instruction only applied to some but not all of the Molyneux evidence?
That's true that the limiting instruction was only given after testimony was elicited regarding what the witnesses believed that they heard occurring between the defendant and his female guest. However, beyond the initial discussion of the admissibility of the threat against Mr. Phillips and the 911 call, defense counsel never requested or reminded the court that he wanted a limiting instruction to be given. And in fact, I believe it was a day after the pretrial colloquy about the admissibility of this evidence, the judge says, here's the limiting instruction I intend to give. He reads the discussion to the parties. It's very clear that that instruction only refers to the domestic violence testimony, and defense counsel never says, oh, but wait, what about the threat, or what about the 911 call? And when that evidence is elicited during trial, defense counsel never objects to the court's instruction. He never asks the court to provide further instruction, and he never specifically asks that the instruction be given with regards to the threat or the 911 call.
Counsel, your adversary has made an issue of the jury notes, 13 of them that came out specifically asking to hear the 911 call. What, if anything, what weight should we give that argument?
I think it's entirely speculative to argue that they were specifically asking to hear the 911 call again because of the threat that was on it, or the testimony about the defendant had already hit his girlfriend. We don't know. There was a lot of evidence on that 911 call, including Mr. Fearon's statement to the EMT, which addresses the second point raised in our brief. We don't know. Maybe the jury wanted to hear the substance of Mr. Fearon's statement to the EMT once more. So we don't know why the jury requested to hear that 911 call again. We know that they did request to hear it, but it would be entirely speculative for us to stand here and argue what the jury was thinking when they sent that note. And of course, by the time the jury heard the 911 call, they had already heard Mr. Fearon and Mr. Phillips' testimony, so the 911 call just supported that testimony. And obviously, there's a second point raised in our brief. Unless your honors have any questions about that or about the first point that we've already addressed, we would ask that you affirm.
Thank you. Rebuttal?
Very briefly, Your Honor, respondent stated that there was no affirmative evidence of domestic violence, but there was in the 911 call where he said he hit his girlfriend several times. And respondent also mistakenly called Mr. Nelson's girlfriend the victim, because the reality is that people view domestic violence differently. It is very prejudicial evidence, as noted by multiple potential jurors during voir dire, and the fact that
Counsel, what actions did defense counsel take with respect to parts of the 911 call that came in?
Defense counsel objected during pretrial
Generally or specifically?
Specifically about the references to domestic violence, and the court did correctly redact a reference to domestic violence that the court had determined happened after the charged incident. So the court found that that wasn't relevant. But defense counsel had objected to both portions, and at the transcript, the pretrial transcript at page 18, defense counsel brought up his objection again and stated, I just want to state for the record that I'm preserving this objection and I won't be objecting at trial as this is elicited because you've already ruled. I'll, of course, object if something else comes to light, but defense counsel preserved their objection with respect to the redaction in the 911 call and the admission of all of the domestic violence evidence, which is why the limiting instruction, the fact that he didn't ask for it, is irrelevant because it shouldn't have been admitted in the first place. And his argument below, which we argue now, is that even with a limiting instruction could not cure the prejudice here, and it's irrelevant that he didn't ask for it because it shouldn't have been admitted in the first place. My respondent also brings up that the jury could have asked to hear the 911 call because it had the statement about the second point in our brief, the hearsay statement to the EMT, but that only adds to the prejudice that Mr. Nelson experienced. That's not a reason why they didn't rely on the other portion of the 911 call that had the Molyneux error. And for those reasons, we ask you to reverse. Thank you.
Thank you. Thank you both. The next case is Barretto versus Groat Street Apartments. Step up, please. You can proceed.
Matthew Rosen on behalf of the appellants in this matter. Your Honor, we have one of those rare cases, a slip and fall on a staircase that is actually caught on video. And the video in this case is clear. The plaintiff walks down the staircase inside of my client's building. He admits that he has no problems going down from the 4th floor to the 3rd floor. But when he gets to the very last step, he clips the last step with the back of his shoe and he falls. His foot was completely on the 3rd to last step. His foot was completely on the 2nd to last step. The only problem he had was that he wasn't holding a handrail. He wasn't looking where he was going, and he missed a step. It's really that simple.
Counsel, with respect to your misstep argument, does it ignore plaintiff's testimony that he slipped because the last 2 steps on the 3rd floor landing were not the same level?
He can,
Well, that's what
I
he
highly
says,
doubt
right?
that it's not the plaintiff himself or the respondent, excuse me, who took these measurements. These measurements were taken by the expert. The height difference that he's alluding to is not specified in any code that was applicable.
So
to
now
this
you're making the uniform argument, right? I mean, the 68, is that your argument? The 68 code doesn't define uniform?
Correct.
But what's the plain meaning of uniform?
Substantially the same.
The same or unchanged?
I apologize for interrupting, not the same, substantially the same, which in this case,
Uniform, I'm sorry, uniform means substantially the same?
you just substantially say, well, let me, in the 2004.
Wouldn't it mean the same, actually?
No, I wouldn't, because even the later codes don't say it has to be exactly the same. The 2004 code says there can be a difference of as much as 3/8 of an inch, which, I must add, by the respondent's own expert's measurements, these steps conform to. They're within 3/8 of an inch. So it even, not only did there was no specificity as to what the uniformity had to be at the time of the incident, at the time the building was erected, but later codes, which do not apply, said it had to be within 3/8 of an inch. So unless we're going to say that the code somehow got less stringent, I would submit that no, uniform does not mean exactly the same. Uniform means substantially the same, because even later codes said it did not have to be exactly the same. And it even complied, in terms of the riser height, complied with the lesser codes by respondent's own expert, which had the riser height as between 7 inches and 7 3/8 inches. So I submit that no, uniform does not mean exactly the same. It couldn't, because then you'd be saying that the codes got less strict in buildings in the city of New York, which I don't think we can say occurred. So we have a case where there is no code violation. There was no code violation based upon the code that was in place, or even later codes, as to riser height, as to slope. His client doesn't even acknowledge what code applies here. Doesn't argue with my expert's opinion that the 1968 code is what applies to this building. He cites the irrelevant codes. Excuse me.
The plaintiff's expert's opinion is based on the 68 code, no?
It is not. The appellant's opinion is based on the 68 code.
But the plaintiff's expert, although he deals with a myriad of codes, he explains why they are in violation of the different codes, correct?
In violation of codes that are inapplicable, sure.
But he includes the 1968 code, does he not?
No, he does not.
I don't know, I thought I read it, sir.
He did not say that it was in violation. He said that uniform should be,
He said it was in violation of the 1968 code, which provided for uniform risers. You may have a different argument about what means uniform, but the expert did in fact say specifically and expressly that it violated the 68 code provision that provided for uniform risers.
I respectfully disagree that that's what he said. He may have a different definition of uniform on his own, but he never provides a definition either.
No, I didn't say that. You're not listening to my question, but that's okay. It's okay. I know what the answer is. I read the affidavit. I know what the answer is. It's okay. I withdraw the question.
I would ask you to re-ask the question. I'd be happy to answer it, Your Honor.
Unnecessary.
Okay.
I understand your argument about what means uniformity.
Respectfully, what means uniformity would have been more succinctly.
I said I understood it.
Well,
I understood that argument. I just differ with you about whether there were references to violations of the 68 code. That's all. Okay. Thanks.
Thank you, Your Honors. Kevin Lillis on behalf of the respondent from the law offices of Patrick Blaney.
Counsel, can you clear that up? Did your expert first refer to the 68 building code? And second, how should we interpret uniform?
So on page 8 of the report, which was attached to our original affirmation and opposition. It says the building code of the City of New York, 1968 to present, requires, it says risers and treads, riser height and tread width shall be constant in any flight of stairs from story to story. Then he goes on to give the opinion that there is a differential in height within the risers, and he's applying it to Code 1968. So he references it in his report, and he says that there's a violation.
So what does uniform mean? Does it mean it's the same? Does it mean it's substantially the same?
I would say it means the same, and also constant.
But your adversary points out that subsequent codes talk about differential. So that, of course, that means that 68 code doesn't mean the same. It would be more reasonable to interpret that it has to be substantially the same, no?
I would partially agree with that, but what I would say is that, yes, they would need to be, at a bare minimum, substantially the same, but what I would point out to here is, let me just get to this sheet where the measurements are, is that defendant's expert Weinstein just provides no measurements at all. He doesn't give a measurement, that one number. He just says the treads were relatively flat. He uses a general term, relatively flat. To me, that's not in conformance. And then he says treads were slight.
But that's a different argument, and I think what my colleague is asking you, which is there anything in your expert's report that quantifies what would qualify as the same or uniform under the 68 code or any other code?
Your Honor, I would have to just take a brief look at his report, but I do have the measurements that he does give.
I know the measurements too. I mean, like I said to your adversary, I read the expert report. I saw the measurements.
It's uniform, I have it right here, uniform to within 1/8 of an inch.
And what is your expert base that on?
That's based on the New York, his report says the New York City Building Code and safe practice requires the riser heights width be constant, uniform to within 1/8 of an inch.
And is that in the code? That 1/8 of an inch?
I believe it's not in the code, no.
Is it an industry standard that your client, that your expert refers to?
He refers to just the New York City Building Code and safe practice requires that it be 1/8 of an inch.
Okay.
I think the main portion of the argument is that the crux of what the defendants are saying here is that the accident was just caused by a misstep. I think the question of fact is, what caused the misstep? We don't disagree that there was some sort of a misstep, whether part of his heel was on, part of his heel was off. It's just what caused the misstep.
So wouldn't it be fair to say if your client had been holding on to the handrail, he wouldn't have fallen?
The testimony from my client about the handrail is that he was holding on to it. Then when the accident happened, he was no longer holding on to it. Then the question was asked again, well, were you holding on to it when the accident? Were you not? He said, I really don't remember. So the testimony on that would have to be fleshed out in front of a jury, and there'd have to be further questioning, which there was questioning that was allowed at the deposition.
Let's assume he wasn't holding on to the handrail, and I apologize for not getting it too early. Does that go to causation, or does that go to comparative fault?
I would say comparative fault. As far as just going along with the point I was just on, the question of fact being how is the misstep caused, is we're saying it's because of the non-uniform risers. Defendants are saying there's nothing that caused it. So there's the question of fact right there, but Morletta, like I said, he cites the 1968 building code, which says it needs to be a constant height between the risers. The plaintiff testified specifically, I'm going down, but the steps are not the same level. So there's the defect there. And then as to causation, if you look at the Rodriguez v. Leggett Holdings case, which is 96 AD 3D 555, it specifically says the court held that although defendants established their entitlement to judgment that plaintiff could not identify the cause of his fall, the court held that plaintiff raised triable issues of fact as there was expert evidence that the treads were not level and worn, and although plaintiff could not identify the cause of the accident, it was enough that the plaintiff identified the site and location of the fall, which my client did, which was at the bottom of the staircase, and then that an expert subsequently identified a defect there, and that was enough to create a question of fact. Thank you very much, Your Honor.
Thank you.
Very
Rebuttal.
briefly.
Go ahead.
Thank you. Very briefly, Your Honor. The reference to a 1/8 inch is, there is no reference to 1/8 inch in the New York City Building Code. This is a good and safe practice argument provided by this expert.
But you've acknowledged yourself that there can be a small differential, right? So is this within that small differential? I mean, does your expert actually address that issue?
Whether
Whether or not the differential here, that they're substantially the same, does your expert deal with that issue?
Yes, he says that these steps were code compliant according to his measurements. He
But
says that that's,
but the 68 code, does it have a differential that's permissible for uniform?
it doesn't say it.
Does not.
Does not.
Your expert came up with 3/8 of an inch, correct?
No.
So what did you argued 3/8 of an inch?
The
Where did that come from?
2004 code,
For the later code?
later code said 3/8 of an inch. That's where he comes up with that. And these steps were within 3/8 of an inch, even by his own expert's measurements. The 1/8 of an inch doesn't exist. It's a good and safe practice argument, which is not acceptable unless it adheres to an applicable code. The issue about the handrail, I must point out, the video demonstrates that the plaintiff let go of that handrail before he got to the step on which he fell. That is clear as day. There is no dispute about that. And even if this court wants to find that there's an issue of fact, which we don't concede, as to a code violation, the fact that the plaintiff admitted that he was able to walk down the steps without a problem, that there was no issue with lighting, height, and with anything, and his foot was completely on the third to last step and the second to last step, this demonstrates that these alleged violations of code did not cause his accident, because he was doing perfectly well until he says he never had a problem before this day. He never heard of anybody having a problem before this day. This clearly demonstrates there's only one conclusion that can be drawn, is that he fell because of his own negligence.
Okay.
And with that, I submit.
Thank you. Thank you. Thank you both. Dennison versus 300 East 57th Street. You can proceed.
Thank you, Your Honor. Good afternoon. May it please the Court. My name is Neil McGillivray, and I represent plaintiff appellant in this matter. Your Honors, I believe I'm correct in saying that in the more than 40 years since the Court of Appeals decided the Nallen case, judgment as a matter of law has only been upheld by this Court in one of two situations. Either there was no prior notice of a risk of criminal activity with regard to the building in question, or else reasonable security measures wouldn't have stopped the activity at issue, either because it was a preconceived, targeted plan in terms of the victim in question, or else the criminal activity was carried out by...
So what should the doorman have done in the circumstances presented to him as the two people walked in?
Well, what he should have done, Your Honor, is what he said he did, which we know he didn't do, which is, according to the doorman, before my client, the plaintiff, and her assailant entered, he said that he stopped the two of them at the door.
First, did your client and the alleged assailant, did they come in together?
She came in a number of feet ahead of the assailant, meaning the assailant was trailing maybe 3 or 4 feet behind her. Now, according to the doorman, he spoke to my client at the door before she came in, or as she was coming in, because he had seen Ms. Wachowski coming in behind her and asked her, "Are you together?" And according to the doorman, my client said, yes. That's what he should have done. We know that's not what he did in fact do because of the footage from the lobby. So once that doesn't happen, and my client has already passed him by, what he does in fact do is he speaks to Ms. Wachowski. She tells him that she's helping my client home. We know that my client was, at a minimum, severely intoxicated. It appears she may have been drugged that night too, but she certainly was severely intoxicated. The doorman obviously relies on what Ms. Wachowski tells him, which is a complete breach of the building's own protocols.
When they reached the elevator, wasn't there an embrace between the two women at the elevator, maybe indicating that they knew each other?
Yes, well, there was, Your Honor, there was what has been characterized as a hug or an embrace. I mean, it's initiated, again, the footage makes clear, it's initiated by Ms. Wachowski, and no different than the previous, as it were, indication from the video footage of my client raising her arm, that embrace too is a matter of interpretation. And what the lower court did was it made a finding of fact in terms of what the embrace, if that's what you want to call it, signified. Now, it's not for the lower court to make that finding of fact. It's not for the lower court to interpret the video footage. That's solely a matter for a jury. And the problem here, Your Honor, is that we have two things that the video footage shows. It shows my client raising her arm in the air. It also shows that embrace at the elevators. They're both matters of interpretation in terms of what did they mean.
So what do you say? What do you say? Well, from the perspective of the doorman, what does that mean?
Exactly. And the thing is this, the problem we have here is that the doorman gives a completely different account. But it's a matter for a jury to determine what exactly does my client raise.
But I'm asking you, from the perspective of the doorman, when the doorman sees the entire interaction, your client comes in, he asks a question, she waves her hand, they go, and then there's some sort of embrace. From the perspective of the doorman, what does that mean?
Well, we don't know what it means because...
Well, doesn't it mean that it's reasonable for him to believe that they were together?
Well, Your Honor, that may be, but that's for a jury to decide because the question of fact, we can't decide that as a matter of law because as a matter of law, that would mean that that's the only possible...
Well, what else is there in the record that would contest that? What else?
Well, what's in the record is the fact that Ms. Wachowski was an intruder. What's in the record is
Why?
Well, she assaulted and she
Well, we know she assaulted her. But what do we have in the record that says that they didn't come in together?
Well...
We don't know where they met, right?
No, we don't. And obviously, we see from the footage that Ms. Wachowski trails in after plaintiff, but in terms of what makes it negligent or not, the building protocol requires the doorman to ask the tenant, is this other person with you? What the doorman did here was the opposite. He didn't ask the tenant, he asked the other person. Who are you? What are you doing here?
And the tenant heard that, though, no?
Well, Your Honor, we don't know because...
We don't know. Okay.
And again,
she was intoxicated. Okay.
Indeed.
All right, let's hear from the other side, please.
Good afternoon, Your Honor. My name is Robert Suarez. I represent the respondents in this case. Unless the court has any questions for me, I think the respondents will submit on its brief.
No, I have a question. Why isn't your adversary correct that the interactions of the two is subject to interpretation and that the court shouldn't be making that interpretation? That should be up to the jury.
Well, Your Honor, it is not subject to an interpretation. And the focus is what does it reasonably appear under the totality of the circumstances? You have two women coming in together. They're walking.
Well, first, do they do they come in together, or is the assailant behind the plaintiff?
Just to set although it's not an issue here, there is no facts in this case that, one, the plaintiff was, the appellant was robbed or attacked in her apartment. We don't know what happened there, but that's not really the issue. What we see and what we know about what the record establishes in this case is that one, there's no evidence in this case of any prior criminal activity in that building. Number two, you have,
Well, the issue is whether or not the doorman followed the procedures when people come in. That's the issue. So was the plaintiff in front of the assailant?
plaintiff was walking first with the Ms. Wojciechowski immediately behind her.
Okay, so come to the door. The doorman does what then?
Doorman stops and asks them while they walk by, "Are you guys together?"
And what happens then?
You see the appellant raise her arm, and then immediately afterwards, Ms. Wojciechowski raises her arm. Then, most important, afterwards, you see the two women embrace in front of the elevator. Taking all those circumstances together, it was reasonable for the doorman to assume that those two were, in fact, together. What appellant is asking this court to do is to require a doorman to go further than that. And I think that everyone sitting here would be a little bit offended if a doorman would start questioning them about who they're bringing into the building. And I think respondents under this scenario submits that the motion court properly decided the motion and found that, one, the doorman did what he followed his procedures. Two, he stopped. Three, the totality of the circumstances appeared, and he was reasonable to conclude that the women were together. And fourth is that there's nothing in this record that would show that Ms. Wojciechowski was an intruder in that building.
And is there an issue of foreseeability that plays into this analysis? In other words, should it have been foreseeable for the landlord to, or the landlord's agent to see that there was going to be an attack?
There's nothing in the record, Your Honor, that would make it foreseeable under these circumstances that we have here that Ms. Wojciechowski was any threat to the appellant. In fact, the two women came together, and the appellant responded that, yes, this woman was with her, or waved that she was. Ms. Wojciechowski did the same thing, and then immediately after, they started to embrace. Under those circumstances, it was reasonable for the doorman to conclude that these women were, in fact, together.
Sir,
And there's nothing in the record that indicates Ms. Wojciechowski was an intruder in this building.
I'm sorry, sir. Would you agree that the affidavit by the assailant presented in the renewal motion, putting aside procedural lateness of that affidavit, pretty much corroborates everything you're saying here?
Correct. I don't think that the affidavit of Ms. Wojciechowski really changes this analysis. It just corroborates the record, the facts that were already in the record. It doesn't change anything. Unless the court has any other questions from me, respondents would submit on the remainder of its argument on its brief.
Any questions, colleagues? Okay, we'll hear
Thank you, Your Honor.
Thank you. We'll hear some rebuttal.
Your Honor, opposing counsel, the question he posed at the beginning of his argument is, quote unquote, how did it reasonably appear to the doorman what he observed that particular night? Framed in that way, that is a question of fact. That's a question only a jury can answer. How did it reasonably appear to him?
I'm sorry, counsel, couldn't we find, or actually affirm the trial court finding that, in fact, based on the record, that there was compliance with the procedures?
I don't believe so, Your Honor, because the procedure required him to find out from the tenant who the other person was.
So if the tenant waves her hand and keeps walking,
right,
and then the assailant, your words, follows and the two embrace, what more can the doorman do at that point? Should he interrupt and stop them from going upstairs?
No, what I think he should have done at that point is, obviously, it may be fair to say that he didn't have a full opportunity to speak to the tenant at the door because she came in ahead of the assailant. But once he realizes that there's somebody else coming in, and he says something, and my client raises her arm, I think we would suggest the proper interpretation there is that she heard her name and she raised her arm. She's not, as the court below said, waving him off. But then when they reach the elevators and you have the hug, what the doorman has not done to this point is actually speak to the tenant, my client.
But did the doorman hear the assailant, Ms. Wachowski, say to the doorman, "I'm taking her home"?
Well,
And she didn't say a word. So what is the doorman to do? When Wachowski says, "I'm taking her home and I'm gonna use the bathroom," and the plaintiff hears that and does not say a word, what is the doorman supposed to do with that information?
well, I think what the doorman should have done is, rather than stand there looking at them, he should have walked to them, standing by the elevators while they were waiting for the elevators, and asked plaintiff, "Is this lady with you?" He could have done that. That would have been a simple measure on his part. It would have complied with the building protocol, which is to find out from the tenant whether or not the other person was with her. The other thing he could have done, and it would have been a simple measure, is that he could have looked at the video monitor that was at his desk to make sure that they went to the 11th floor. Obviously here, that's not what happened. But I think the simple measure, in answer to your question, Your Honor, is the building protocol required him to find out from the tenant. Whether or not he had a proper opportunity to do it at the front door, he certainly had an opportunity to do it while they were waiting for the elevator. What we see in the footage
So in other words, he should have interrupted the hug and said, "Are you together?" I don't quite.
I understand, Your Honor, but the hug is only momentary. The hug is not, it's not a long, drawn-out embrace.
It's a hug, not a punch.
Yes, but, and I think I say in my papers, if Ms. Wachowski in this case were male rather than female, and you have a situation where a highly intoxicated female resident comes into the building, a male trainer...
But he doesn't know that. The doorman doesn't know that she's highly intoxicated.
Well, he doesn't know that, but he should have known that.
He should have known that.
He should have known that, because he should have engaged with her, in which case he would have realized that. We see her in the elevator fall down the minute she gets inside. What, in terms of...
So a doorman has the responsibility when any tenant walks in to ascertain their competency and whether they're under the influence?
No,
I just don't understand that.
No, I wouldn't say that, Your Honor, but he does have the obligation, according to the building protocol, and we would also suggest that that's the applicable standard of care, to ask to find out from the tenant, as opposed to the other person.
I'm not sure that's the standard of care in a case like this.
Well,
it's not what the building protocol is.
Well, you know what, Your Honor...
And in fact, I'll ask you the question, and I know you're over your time, but I'm going to ask you the question anyway, that I asked your adversary. Where does foreseeability play into this? How is this foreseeable by the doorman that your client was going to get attacked on the 5th floor?
Well, the question, I think, Your Honor, is, was it unforeseeable as a matter of law? I think it's fair to say that when he observed the hug, it was unlikely that what actually happened was going to happen. But the question on summary judgment is whether that was unforeseeable as a matter of law. And I think this court, the Court of Appeals, have been crystal clear in terms of how limited the circumstances are where something is unforeseeable as a matter of law. I agree it was unlikely, or it may have appeared unlikely, but as a matter of law, I don't believe that that hug could possibly sever the causal link.
Okay. We're good. Thank you.
Thank you very much,
Thank you
Your Honor.
both.
I'm going to ask another question, but it didn't make any sense anymore. Just going to prolong the agony.
Rodriguez versus 3rd Avenue Transit. Step up, please.
Good afternoon, Your Honors. Jillian Rosen for the Plaintiff Appellant. Thank you for giving me a few minutes. I know my adversary isn't here, so I'll make it quick. The crux of our appeal is that the trial court erred in finding that the defendant met their burden. The defendants did not meet their burden on summary judgment. If you look at 387 of the record, they submit 2 reports, 2 IME reports. 387 of the record is Dr. Goldstein. Dr. Goldstein fails to examine plaintiff's thoracic spine, which is an injury claimed in the bill of particulars at 343 of the record. In addition, Dr. Goldstein admittedly reviews the CDs, the MRIs of the lumbar and cervical spine, but he fails to, so he reviews these, and he fails to reconcile the fact that if you look at 391 of the record, he reviews a prior report. The plaintiff had an accident in 2012, and he was basically asymptomatic at the time of this accident. So he fails to establish that the bulging discs that he actually sees on these MRIs were not traumatically caused by the car accident, as opposed to something else.
Doesn't he say that the MRIs show degeneration?
Not Dr. Goldstein, Dr. Cohen. Let's look at Dr. Cohen at 395. At 395, the Dr. Cohen has similar deficiencies as Dr. Goldstein. Actually, Dr. Cohen's is worse. Dr. Cohen doesn't look at the CDs. Dr. Cohen relies on the reports. And here's what Dr. Cohen says. Dr. Cohen says that the reports show indicia of degeneration, but I can't be sure without looking at the films directly. This is 398 of the record. So he doesn't establish a lack of causation. In addition to not establishing causation, or a lack of causation, Dr. Cohen does not establish that the plaintiff didn't sustain an injury in the permanent, consequential, or significant limitation. And look at 398 of the record. At 398 of the record, Dr. Cohen says the following. He has no pain with straight leg raising on the left, but he does have pain with Patrick's testing maneuver on the left into the groin. Doesn't say to what degree, doesn't say if it's a positive finding. Straight leg raising and Patrick's test maneuvering on the right gives him pain in the back only. So now we're 4 or 5 years post the accident, and this doctor is eliciting pain on 2 orthopedic tests that are evidence of positive signs of serious injury, but he doesn't establish what the range of motion was, where he feels the pain, and if this is a positive finding. So our position is that Dr. Cohen and Dr. Goldstein failed to establish their burden, and despite how deficient our proof is, which I don't think it's deficient, because Dr. Wiener, one last thing, Dr. Wiener at 487, our doctor, I'm trying to go as fast as I can.
Well, it's not that. You don't have, we do have your briefs, and we have the record on appeal,
Okay.
and you don't have an adversary here.
Okay, so
I gave you 2 minutes.
Okay, so then I would just close by asking you to look at 487 of the record. That's Dr. Wiener. That's the plaintiff's doctor that finds signs of serious injury that certainly raises an issue of fact, if you were to even shift the burden. Thank you for listening.
Thank you.
Okay, thank you.
Okay. Tiny One versus Samfet. You may proceed.
Good afternoon, Your Honors. Jesse Conan for the defendant appellants. So my plan is to focus on the statute of limitations for the fiduciary duty claims. We contend it's 3 years because plaintiffs seek monetary damages. Plaintiffs say 6 on account of fraud. And the core issue here is how to assess a fiduciary duty claim seeking monetary damages, typically subject to a 3-year statute of limitations, when the plaintiff contends that the 6-year fraud statute applies. And it's a common tactic utilized by plaintiffs to try to save otherwise stale claims.
I wouldn't necessarily call it a tactic. It's a rule of law, right? It goes back to Kaufman versus Cohn.
Sure.
You said it. So the question is, leaving the tactic behind, which side of the equation does it fall on? Go.
Which side of the equation does it fall?
Yeah, well, does it fall on the breach of fiduciary duty only for money damages, or is it a Kaufman v. Cohn, a fraud-based breach of fiduciary duty?
So there's 2 prongs to the analysis. First, the plaintiffs have to establish that within the breach of fiduciary duty claim, there's an actual cause of action for fraud, essentially. All the elements of fraud must be embedded within the breach of fiduciary duty claim. And the simple allegation, though, of fraud is not sufficient.
Okay, so let's take a more specific allegation. One of the claims here by the plaintiff is that he contributed $850,000 based on the alleged false statements by defendants with respect to an $11 million contribution, correct? That's one of the claims.
That's one of the
So
one of the four,
does that-
one of the three injuries.
So
Correct.
does that
Well,
sound in fraud based on an alleged concealment?
well, there's first of all, I think you have to take each of the injuries separately. So you have to look at each of the breaches of fiduciary duty related to each injury separately. So you have to analyze that $850,000 contribution. And I think where that claim fails is not so much, that's the most fraud-like claim they have, fraud-like fiduciary duty allegation they have in the complaint. And where that particular claim fails is where they try to allege an injury. Because what you have there is you just have one plaintiff contributing $850,000 to the company, of which he's 100% owner. So he's essentially just trading cash for equity. There's no actual harm related to that specific bad act. So that's where that claim falls short.
So would you concede actually that there is a fiduciary duty here in this case?
No. Well, with respect to certain defendants, I think that the defendant, as they allege, I think the defendant, Coyle and Giambra, they allege that they're employees and officers of the company. And I think certainly officers of a company have fiduciary duties to the company. We dispute the fact that Orbeck and Burberry, defendants Orbeck and Burberry, had fiduciary duties because they were not employees or officers of the company. So we certainly wouldn't concede that, no.
But through their actions in controlling the company, managing it while plaintiff was otherwise incapacitated, wasn't there a fiduciary duty created through their actions?
Well, first of all, I don't think that the plaintiff alleges that he was incapacitated through this whole period. He does allege that he ceded control of the company. And I think that we should be very careful here because in this context, the parties were in a very adversarial posture here. Certain plaintiffs were purchasing defendants' company. And I think given that adversarial posture under some of the case law that you have, it's simply, there can't be fiduciary duties given the adversarial posture.
You're making it appear that they were just the deal counterparty. I mean, that's what you make it appear. But the allegation is that your clients essentially took over as part of their due diligence of the running of plaintiff's company and defrauded the company in various ways.
Well, that's where I think that the, I was hoping to focus on the statute of limitations and whether they really did allege that there's a fraud.
It's a tied question, right? Because as my colleague points out, if it's a fraud-based claim, then it's 6 years. I mean, that's what we're assessing.
Right, exactly. And I think that the key part of the fraud inquiry is that not only do they have to allege an actual fraud, but they have to further show that this fraud was the direct and essential cause of the injury. And the question there under Powers, which is a key...
And is that true for a 3211 motion? I mean, we're talking about a pleading right now. And you're putting up a pretty heavy burden for a pleading about proof of damages.
But
essential.
It's not proof of damages, though. And these cases that came up, I don't think they came up on summary judgment. I think they came up on a motion to dismiss.
Probably because it's a statute of limitations.
So I think, and that's the key here. So in Powers, for instance, like here, the allegation is that fiduciaries did not disclose certain wrongful acts. And what Powers said is that the fraud is extraneous to the breach in that case. Because if you strip the fraud away, they still have their breach of fiduciary duty, and you have the same thing here. With respect to the Samfit transfers, the key question is whether those transfers were wrongful. You could strip all the allegations of concealment away, and we contend that they were disclosed under their allegations.
And how were they disclosed? How were they disclosed in this case?
They were disclosed, they appeared on the bank statements.
Oh,
that
were those bank statements, for example, given to the plaintiff, or were they sent to the office?
They were sent to the plaintiff. Well, there's two plaintiffs. There's a corporate plaintiff and an individual. They were sent to the corporate plaintiff's offices.
Right, and where was the individual plaintiff at that time?
But with respect to the individual plaintiff, there's no duty of disclosure under New York law This general duty of disclosure with respect to shareholders doesn't exist. And that is the only capacity in which...
But the corporate plaintiff, your clients, at least allegedly, were running the corporate plaintiff, right? They were the ones running it.
Well, it's a large company. It's not a two-person operation. This is a very large company with an accounting department and lots of officers, multiple offices. So they do allege that we were running it, but the fact that it was disclosed to the company is, I think, undeniable. I mean, it was disclosed. The banks, it was on the bank statements.
Okay.
So, but I think that the key question, well, I see my time is up, so.
Okay, you'll have time on rebuttal. All
Okay,
right.
fair enough.
Thank you.
Thank you, Your Honor. James Kennedy of Kennedyberg for the respondents. I think that my distinguished colleague's argument has shown the wisdom of what Justice Ostrager said. This is a case of competing narratives, and the defendants cannot sustain any of their arguments without taking the complaint that we have drafted and reducing it to a sliver of the wrongdoing that we've alleged, which is the transfers of the money over the transom.
So why don't you address that? So your adversary argues that there was disclosure, at least to the corporate plaintiff, and presumably, I guess, there can't be reasonable reliance then, since it was there to be seen, right?
Your Honor, first, with respect to just the transfers alone, the transfers were not disclosed, we've alleged, to anyone who had any control. What happened is that Mr. Berberi, Mr. Orbach, came in, and they immediately began making these transfers to Samfit without any consideration. To the extent they were in bank statements, there's no record. We just have, at this point, allegations. There's no evidence that the banks, that any of this was brought to the attention of my client or brought to the attention of any officers or persons within Port Morris Corp. Who could have let Mr. DeLazaro know what was going on. And it's a matter, to begin, of concealment. There is a duty of disclosure, and Justice Ostrager said we had pled that even Berberi and Orbach had obligations that were fiduciary, so they had an obligation of disclosure. And actual fraud, Cusimano says this, and let's be clear of it, actual fraud includes fraudulent concealment. But beyond that, they artificially reduced not only Berberi and Orbach, but they brought in a man named Giambra, who was our CFO, who it's been conceded had fiduciary obligations. They brought in Coyle, who was assistant controller. It's been conceded they had fiduciary obligations. And if we allege a breach of fiduciary obligations sounding in fraud by those two individuals, everybody comes in because we have aiding and abetting here. And there's been nothing said today about the fact that we have pled an act of substantial assistance by every defendant, either directly and with respect to the corporate defendants, from control persons who were wearing two hats and assuming loyalties to us and violating it. But let me just go to the larger point here, which is that in addition to the wrongful diversion, Giambra artificially reduced and rewrote our books and records. Didn't tell us, didn't show it to it. There's even allegations that we were telling him, you have fiduciary duties, we need to see our own books and records, wouldn't let us see them until when? April of 2017, which is within 3 years, when you take into account the tolling, 3 years of the filing of the complaint in March 2020. So it was April 2017 to May 2020, but the tolling was effect. Artificially rewrote our records. Increased our loans with M&T Bank by threefold, by $4 million, which took $4 million out of my client's pocket when he sold the business because he had to pay off the bank. And we allege that artificial increase in the debt was to send more money to Samfit. Misrepresented the financial information. Affirmatively said in November 2016 to my client, Samfit has contributed $16 million in cash. And as Justice Singh pointed out, yes, that resulted in my client pocketing putting $850,000 in cash to the business in anticipation of an asset sale. That's money that my client lost because he put the money into his own business, yes, but the deal was that the cash went to the buyer. And he did that without knowing that it was an outright lie on the part of Mr. Breslin, Mr. Coyle, and Mr. Burberry, who attended that meeting and said, Sanford has contributed $11 million, you've got to pony up $850,000. So in effect, the theory here, and look, it's an unusual case in the words of the trial court, and we thought long and hard of what was the proper legal grounds on which to allege this case. And as we looked at it, you've got individuals who came in, took over our business, some of whom had official titles, were paid handsome salaries, they had fiduciary duties, and they were rewriting our books and records, making transfers that are insider transfers for no consideration that would violate the debtor and creditor law of this state, engaging in contract that was not only sounding in fraud, was wholly characterized by fraud. There's no credible argument here that that conduct was merely incidental. And the cases they rely on, and I'll wrap up, including Power, are not cases that deal with fiduciary duties. You know, it's one thing to have just a straight commercial relationship and say, well, there's a contract here, but there was concealment, where there's no obligation of disclosure. Here what you have are individuals who had fiduciary duties and obligations to tell the truth, obligations to disclose, and instead what they did was they concealed. And under Cusimano and under Kaufman, concealment is actual fraud, and even if we're seeking money damages, where there is actual fraud in a breach of fiduciary duty claim, the statute of limitations is 6 years. Unless there are questions, I thank you for your time.
Thank you. Rebuttal?
Sure. Thank you, Your Honors. So there was a lot there. With respect to the books and records, they allege that the books and records were recast by defendant Mr. Giambra, but they don't at any point allege that they ever relied on those books and records. In fact, they state and they allege that they did not rely on them. They did not believe them. There's no injury flowing from that. I think my colleague here, he talked about Powers and said that that case wasn't about fiduciary duties. It was. All the cases we've cited are about fiduciary duties. And I just want to turn now to the analysis that's required to convert a fiduciary duty claim into a fraud claim. So under the second prong of the analysis, they must allege a fraud essential to the breach. And plaintiffs fail to meet this element when the supposed fraud comes in the form of an officer's non-disclosure of wrongful conduct. And that's the precise nature of the fraud here. So in each of Powers and Pollock, which is an old case, but one I think that has a lot in common with ours, the wrongdoing in those cases was an employee or officer's non-disclosure. And the courts there said that that's insufficient to transform a breach of fiduciary duty into a fraud, because the injury is the misappropriation. The injury in our case is the transfer to Samfit. And if you strip away the allegations of concealment, that core misappropriation remains. So they can lose on their allegations with respect to the fraud and still win if the misappropriation was not for adequate consideration. They still have their breach of fiduciary duty claim. And that's what the test really is. And I think that Kaufman and Powers, I think, provide a nice contrast. Because in Powers, there was a fiduciary duty, and there was a corporate opportunity. There was the case dealt with a misappropriation of a corporate opportunity. And in Powers, the plaintiffs complained that the corporate opportunity was not disclosed as it should have been. And the court said, no, the injury there is the misappropriation. The fact that you've alleged it was concealed does not add to the claim. It's superfluous, and therefore it's subject to a 3-year statute of limitations. Kaufman, in contrast, if I could just finish and that'll be it. Kaufman is another First Department case. And there, the breach was the fiduciary's misrepresentation about the salvageability of an investment. That representation was detrimentally relied on by the plaintiff based on the misrepresentation, and that plaintiff declined to salvage the investment. So the claim, the actual wrongdoing there, is the fraud. And plaintiff's decision not to salvage the investment is only actionable because it was induced by fraud. So in Kaufman, the fraud claim is essential, but in our case, it's not. You can strip away all the fraud, all of their kind of smoky allegations, and the heart of the case is really about, were these transfers wrongful? And that's not a fraud claim. You don't need the fraud. It's gratuitous. Thank you.
Thank you. Thank you both. Foster versus Kassab.
May it please the court, my name is Brian Shute. I represent the plaintiff Dorothy Foster. As you know from the briefs, this is a case where the plaintiff alleges that there was malpractice in January, February, and April of 2017 in failing to diagnose, or really even attempting to diagnose, what turned out to be gastric cancer. And we submit, Your Honors, that while the defendants received summary judgment in the lower court, they did so as a result of a separate and decidedly unequal weighing of the opinions of the respective experts, and that the court should not have even reached the sufficiency of the plaintiff's opposition proof because there was no prima facie case, either as to malpractice or as to causation.
Oh, yeah. Could you address causation? Why wasn't there, at least with respect to the causation issue, a prima facie based on what the expert testified?
Certainly, Your Honor. The defendant's proof of causation, you will find it. It's one paragraph. It's page 1654 of the record, paragraph 19. If you skip that, you've skipped their proof of causation. The judge below criticized the plaintiff's expert responsive proof as to causation on the grounds that the plaintiff's expert, A, didn't identify what stage, didn't identify whether there was gastric cancer at those points in time, January, February, April, and B, if there was, what stage there was. When you turn to the defendant's proof, this is the movement, making a prima facie case supposedly on the issue of causation. You will find, Your Honor, first and most obviously, those same deficits apply to their proof. There is no allegation in this paragraph on causation as to whether the plaintiff had gastric cancer or at what stage in January, February, April. We cite a case in our brief.
Why do they have to do that? Don't they? They do indicate, and it's undisputed, that your client was diagnosed in, I guess, the earliest in October of that year, correct? And that at that time, as I understand the move-in's affidavit, that at that time, there was no surgical treatment option available, right?
Correct again.
They say that, and that they treated him, the protocol was, I guess, some chemotherapy, and that it was an aggressive form of cancer, and that by the time you otherwise diagnose it, it has a very poor prognosis. That's not enough?
No, Your Honor. There was a case we cite in our brief, Fellanco versus Reed. It's a 2013 decision by this court, which I know is correct because you were on that panel, Justice Gish. And you wrote, ironically, or the court did, it wasn't signed. The motion court's criticism of plaintiff's expert affidavit, the issue there, Your Honor, was failure to diagnose micro-AVM and there should have been an angiogram, plaintiff's claim was.
Yeah.
And the court noted that the very criticisms that the lower court had made of the plaintiff's expert's proof on causation would hold equally for defendant's expert. And my point is, that's exactly the same here. The same exact deficit. The standard should not be higher simply to raise an issue of fact as to obtain summary judgment in the first place. But it goes beyond that, Your Honor. It goes beyond that. Not only is there, in that one paragraph I mentioned, which is the only paragraph on causation, not only is there no information as to what stage this cancer was at, or if there was cancer at any pertinent point in time. Not only that, but the expert doesn't say, we know some people survive of gastric cancer. We know some people don't. I've cited cases decided by this court, Shaw versus Cooper, and one by the Second Department, Vorowski, people surviving gastric cancer. What in the world does this expert see in this case that leads him to believe this is not a person who had a substantial chance of survival? What fact? Something they found in January, something they found after diagnosis? There is nothing. There is no explanation at all as to why in this particular case this person had, and remember, medical causation, the appropriate standard is merely a substantial chance of recovery. That's what the plaintiff would have to prove at trial when the plaintiff has the burden of proof. No explanation whatsoever as to why this plaintiff was doomed. How could it be more conclusory than that? And in fact, when you look, I'm sorry for keep on pulling my mask up. When you look at that paragraph, here's another striking thing about their proof of causation. There is not a fact in it specific to this case. There's nothing about this patient in their allegation, their expert's allegation about causation. Nothing that makes this decedent less likely to be a survivor than anyone else. How could it be more conclusory than that? With respect to the malpractice issue, which I'll address if the court wishes me to do so.
Yes.
Balzara, he's the internist who sees the patient first in January and then again in April. Defendant argues, I want to quote this exactly, there is no rule that an expert in a medical malpractice case must expressly discuss every medical visit when rendering an opinion. We allege he was negligent on one occasion, April 2017, where at that point the patient comes back, has had epigastric pain for 4 months since the infection resolved in December 16, and sends the patient home without doing anything. Yes, when there's one visit where the doctors claim to be negligent, I think it is incumbent to address that visit and give some explanation as to why that was not malpractice. With respect to, particularly since the global explanation for doctors Balzara and Dr. Persia didn't even fit. Why the two of them were collectively met all standards of care was, quote, they heeded plaintiff's complaints at each visit and recommended appropriate treatment and testing, except that in April, there was no treatment recommended and there was no testing with respect to the complaint.
That's the claim that there should have been an EGD? Is that your claim with respect to that particular date?
Yes, Your Honor.
But is that...
there should have been, and I'm going to ask you personally not to ask me to pronounce that. But yes, there should have been an EGD, or indeed...
Well, why wouldn't it be sufficient for the doctor just to refer the decedent for a GI consult?
Well, actually, our expert agreed that when Dr. Balzara initially did that in January, seen by the resident, Dr. Flint and Dr. Balzara, and they send the patient to the gastro for a possible EGD. They agreed they did the right thing. But now the patients come back. It's 4 months since the infection, which was initially thought to be
Didn't
the cause of all this.
the expert determine that particular test wasn't necessary? Wasn't that sufficient then for the doctor to rely on what the expert determined?
No, for a couple of reasons, Your Honor. One, it's now 2 months after the gastro has seen the patient, still has gastritis. But even beyond that, Your Honor, there has to be, this is a motion for summary judgment. There has to be, I would submit, some proof, which, if believed, that the doctor on that occasion conformed to the standard of care.
And one more question. With respect to the treatment on 427, was that raised in your bill of particulars? I don't recall. I think there's an issue about that, no?
I'm glad you asked me that, Judge. In the reply papers below, defendant argued that the reason it wasn't addressed in our expert's affirmation is it wasn't pleaded in the complaint to bill of particulars. That was inaccurate. The argument on appeal is now it wasn't emphasized in the complaint and bill of particulars. Your Honor, not only did the bill of particulars specify this particular date as a time where malpractice occurred, it specifically said there was malpractice, and I'm going to quote from it. Failing, this is at page 189 of the record. Failing to timely and properly refer Mr. Swales back to the gastroenterology clinic, including after plaintiff's visit on February 23 and following his colonoscopy on March 8th. This is from our pleading. And I would suggest that's sufficient that there should be some attempt to address the one date that we said he was negligent and make some explanation as to why that was not the case in the expert's affidavit. I didn't have time for Dr. Kassab.
You'll have some time on rebuttal.
Thank you.
All right.
Your Honors, may it please the Court, Alina Drucker on behalf of Drs. Kassab and Dr.
So counsel, your adversary essentially cites the old legal principle, what's good for the goose is good for the gander. And in this case, with respect to causation, your expert's affidavit is wholly conclusory and therefore shouldn't be considered by us.
Yes, but it's not true. Our expert affidavit explains that linoplastica, this is a very specific, a rare kind of cancer, of gastric cancer. It's not just any gastric cancer. This type of gastric cancer, at the point it is diagnosed, is dispersed through the system beyond the point when surgical intervention can be done. So their expert, so what this does is says, at that point of diagnosis, at the point that it's detectable, unfortunately, it's tragic, but there's really no treatment option. Their expert responds by saying, cancer, it's always better to diagnose it earlier, with absolutely no statement that says, well, actually, let me tell you about linoplastica to rebut the statement about this specific kind of cancer, with something that says, linoplastica, in fact, could be diagnosed 6 months earlier before the patient has even reported this upper abdominal, the new quadrant upper abdominal pain, which is what triggered the EMG that ultimately found as cancer. So before, there's not a statement in their expert that responds and says, well, actually, that's not true. That's what a rebuttal expert would do. It would say, linoplastica could have been detected. In fact, based on the staging, based on the fact that it was detected at stage 4, it would have been the stage 3 or stage 2 or stage 1. It would have been, what our expert said is it's rapidly evolving and you would not have been able to get a different treatment plan at the point it was detectable. The response that...
But your adversary is suggesting that what your expert had to do is say that in February, when they are claiming it could have been diagnosed, that the stage would have been such that it could not have been treated any different. Is that your burden?
That's not our burden, Your Honor, because our burden on the prima facie case, so first of all, I mean, there's not even a, I would love to reserve some time to talk about the fact that there's really no claim of malpractice on either of the 2 visits at issue, but even if you get past that and you say that there could have been a reason to do an invasive test when the patient was just recovering from a serious bacterial infection and a month-long antibiotic treatment, even if you get past that, for the causation point, what we need to be able to show is that, and I've said it, is a substantial chance that there could have been a better outcome.
A better outcome.
Better outcome. And what we've shown is that through our expert, that linoplastica is a type of cancer that when it is detected, there is no surgical intervention. It spreads through the stomach and through the area, and it passes through all of the walls from that organ, which is what happened here. So what we've established is exactly that there's not a substantial chance, as tragic as that is. And the response has to be, the rebuttal has to be staging. And that's what happens in every case, right? A state, your expert is incorrect because here is a study, here are several studies that show the evolution of this cancer. That didn't happen here. But I think even putting causation aside, there's no medical malpractice here. The plaintiff's claim is that on the very first appointment that he sees this gastroenterologist, that's the first appointment at issue, when he reports to the doctor, the patient reported to the doctor that his epigastric pain had resolved. Not just that, a month earlier, the first appointment with Dr. Balzora, it's in the record, he said to the doctor, the burning has gotten progressively better since the treatment started. Now, he had H. pylori, a serious stomach infection. He was treated with a month-long course of antibiotics, 2 antibiotics and a proton pump inhibitor. And during that time, and Dr. Kassab testified that following an H. pylori infection, there's often lingering pain for an extended period of time. She expected possibly having to treat him for pain for several months. She had a series of medications that she said would you sort of go through the motions to treat the lingering pain following an H. pylori infection, which is known to cause ulcers.
Well, and they were, prior to his diagnosis, they did some tests that would rule out cancer tests, correct?
Well, he had a second, he actually had a lot of,
colonoscopies. He had at least 2.
well, he had a separate series of complaints. So what he did was he had complaints, and there were no, from the doctor's perspective, unexplained complaints. He had severe constipation going on multiple years. 7 years he complained of constipation. And the doctors immediately ordered a colonoscopy. The gastroenterologist, that was really the primary basis for the referral, was he came, he said, my epigastric pain is largely resolved, but I've been constipated for 7 years. The doctor ordered a colonoscopy, a full battery of tests to try to figure out why he was constipated. And it's the idea that a doctor can't take a conservative approach.
And they had a reasonable working diagnosis based on his expressed symptoms.
Exactly. For both the pain and the constipation, they were looking to try to whittle down the possibilities that were causing the constipation, at the same time giving him medication to treat the pain.
And at some point, he came in with more alarming symptoms.
That's right. Over the summer, after the 2 appointments, the only 2 appointments at issue here.
Going back to the April appointment, was there an obligation on your client to follow up, to make sure that the EGD is done?
For several reasons, no. So first of all, as Your Honor's noted already, this is the one appointment that Dr. Balzora seems to be faulted for. Dr. Balzora saw the patient, said, oh, you have some epigastric pain, you have some constipation, you have complaints. I'm going to refer you to the GI, a specialist for that. And then Dr. Balzora, he comes back several months later after his colonoscopy. Now, and I'll note, right after his colonoscopy, March 9th, it's in the record at 1637, after the colonoscopy, they're asked about his pain status. He says, pain status, not having any pain. So the doctor gets the notes sees that there's a colonoscopy, sees that there's been a lot of treatment from the specialist, and that he still has pain. The doctor does not have an obligation, now that he's within the care of a gastroenterologist, to send him back to the same gastroenterologist for the same complaints and say, you know, I don't think you did your job well enough. That's not the internist's job here, because there aren't those new pains. And as soon as those new pains happen, like tragically, there are these alarm symptoms that he ends up suffering from over the summer and devolving over the spring, into the fall. He does have unexplained weight loss and vomiting and diarrhea, all of these symptoms, blood in the stool, which lead the doctors to properly order him an EGD. Once he starts complaining about new pain that's not unexplained, for those reasons, unless Your Honors have any questions, that there's no malpractice and causation has been not been established. Thank you.
Thank you. Rebuttal?
I'd like to address the causation point that the court brought up, that there was a working diagnosis for this continued gastritis. There wasn't. Up until December of 2016, the doctors believed, I think reasonably, The man has an infection, he has gastritis, the infection's causing the gastritis. After that point, there was no diagnosis. There was no there was no theory as to what was causing this problem, just that he had it. And there was no diagnostic test ordered for it. And with respect to causation, Your Honor, the point is on burden. We know that the doctor, by the way, McKinney, their expert, did not say that once you have gastric cancer, you die. What he said was the great majority of people they do die. But meaning that some don't. Presumably those where it's detected early enough. So how do we know that this wasn't one of those? There's got to be some reason to convince the doctor that this is where there's no substantial chance of survival. But whatever reason the expert had for reaching that conclusion, he never gave it. He never said anything specific about the facts of this case or about this patient, why there was not a substantial chance of surviving. Briefly, with respect to Dr. Kassab, that's the gastroenterologist who sees the patient sent over for a possible EGD and she doesn't order one. And our point there is that you can't obtain summary judgment by where facts are disputed, assuming the facts favorable to the movement, and then basing an expert opinion upon those facts. The assumption was by the Dr. Burke, who was the expert with respect to Kassab, he assumed it was, quote, undisputed that the patient had no gastric pain when he saw the Dr. Kassab in February. Of course, if that was the case, then it's reasonable not to order diagnostic tests for the gastric pain the patient doesn't have. However, that was very much in dispute, not merely because the decedent testified that he had pain throughout, but also because the January record specifically said, the January record of Lincoln, that the pain had continued after the infection resolved, meaning that the entry, which their expert, Dr. Burke, assumed as fact for the purposes of opinion, was erroneous. The assumption being that the pain resolved back in December. That's what he based his opinion on. And I don't think, to conclude, my red light is on. I don't think that when we're talking about summary judgment and avoiding the day in court, that the law requires, and it's not unreasonable to require, something other than a basic conclusion that whatever we did or didn't do wouldn't have mattered. There should be some reason specific to the case as to why 6 months delay in diagnosing a cancer made no difference, would have made no difference at all to this patient. Thank you for your time.
Thank you. Thank you both. People versus David Woods.
Good afternoon, Your Honors, and may it please the court. My name is Catherine Kuthman of White & Case, LLP. We're serving as pro bono counsel to the appellant, David Woods, along with the Legal Aid Society. Your Honors, Mr. Woods' conviction for robbery in the 2nd degree should be reduced to robbery in the 3rd degree because the people failed at trial to prove, beyond a reasonable doubt, that Mr. Woods caused physical injury to the complainant as required by the penal law. Therefore, his conviction is based on legally insufficient evidence.
Did the complainant, once he was struck by Mr. Woods, was he rendered unconscious?
Yes, Your Honor, and I'm glad you brought that up. Opposing counsel, the people in their brief argue that Mr. Woods perhaps caused the complainant to become unconscious. But here we have an extensive record of testimony and evidence at trial that the complainant was intoxicated at the time.
But he wasn't unconscious when the defendant encountered him. He was actually walking. So we know that he was conscious. And then they came into contact with each other. There was a punch, and then he's rendered unconscious.
So, Your Honor, First of all, we argue in our brief that there wasn't sufficient testimony that a punch occurred. That's our causation argument in the second part of our brief. There was testimony from the eyewitness, albeit shaky testimony, that the two were walking together and that he observed the complainant fall. He testified.
Didn't he testify that there, well, first of all, in the 911 phone call, there was a punch, that he was punched in the face, and then at trial, he was punched from behind, and then punched in the shoulder, but that can be weighed as credibility as to whether or not shoulder, but there was a punch that was consistent.
Your Honor, respectfully, I would disagree. Before he testified to 3 different types of punches through the shoulder, from behind to the face, he testified that the first thing that he saw was the complainant fall to the ground. So even viewing that evidence in the light most favorable to the people, that's not evidence beyond a reasonable doubt.
What did he say in the 911 phone call?
I'm sorry, Your
What did he say in the 911 phone call?
In the 911 call, he did mention a punch, but when he was cross-examined at trial, he testified that the first thing that he saw was the complainant fall to the ground, in addition to testifying to seeing punches. So there's not clear testimony from this eyewitness as to what occurred. But even if there was a punch, Your Honor, that punch did not leave an injury that would be sufficient to meet the statutory threshold here. We have medical records from the night in question. The complainant was taken to the hospital, not because of the injury to his face, he had a mark on his cheek from the alleged punch, but rather because he was highly intoxicated and vomiting on himself.
There was no bruising on his face? There was no swelling?
Yes, Your Honor. There are photos taken of the complainant's face, both the night in question and days later at the district attorney's office.
So doesn't it really come down to what the jury believed? Based on the eyewitness's testimony as to whether or not there was a punch, where the punch was, what happened?
Your Honor, the photographs in the testimony of the mark on the victim's cheek amounted to some redness, some swelling, perhaps a bruise.
But you would agree that it's more than slight or trivial, right?
I would not agree, Your Honor.
He further testified that he was in pain, sore for 2 weeks.
Yes, Your Honor. So the victim's subjective description of the pain was, yes, that he was in pain for 2 weeks and that he was sore. However, the subjective description is just one of the factors.
Well, okay, that's the pain, but he also testified that there were marks on his face for up to 2 weeks?
He testified that there was a single mark on his face and that it completely healed. He described it as a scrape, Your Honor.
But it took 2 weeks,
2 weeks.
Correct?
Yes, Your Honor, that was his testimony.
So isn't that more than slight or trivial?
No, Your Honor. He required no medical treatment for this scrape. His medical record said the primary diagnosis was alcohol intoxication. He was given no follow-up care by the doctor. He was prescribed no medicine by the doctor. The only thing he did was self-administer Advil, and this court has ruled before that that type of medical treatment or lack thereof is not sufficient to constitute an objective level of impairment of physical condition or substantial pain. That's the inquiry here. Yes, we have the victim's subjective description of pain, but this wouldn't be the first time this court ruled that that subjective description is not compelling. For example, in People v. Contreras, the complainant there also went to the hospital, had a 1/4 centimeter mark on her arm, but it didn't cause her to not be able to move her arm. The wound was simply cleaned and applied with the butterfly stitch. At trial, she complained of pain. She testified to it in court, but this court said that while her pain is purely subjective, the testimony is purely subjective, it's only one factor to be considered. And we're of the view that the pain that she complained of did not reach the objective level required to constitute physical injury. We argue it's the same thing here. The medical records show no medical treatment. The testimony of both the responding officers and the eyewitness describe it as, at best, a single bruise on his face. The medical records don't require any medical treatment. The photographs themselves, which Your Honors can see, which were admitted into evidence, show some redness, a bit of swelling, perhaps a single bruise, but that's not sufficient to constitute physical injury. Moreover, in a matter of Jose B., the court said the exact same thing. That was this court as well. The juvenile complainant there was hit several times. Now, reminder here that Mr. Woods allegedly hit the complainant 1 time.
Well, 1 time, and according to the eyewitness, sufficient to knock him to the ground and render him unconscious. So maybe slightly different than the case you cite, right?
Yes, Your Honor, but we would disagree that the evidence was beyond a reasonable doubt that he caused him to be unconscious. Remember, this victim testified at trial to blacking out from alcohol intoxication. He has no memory of meeting Mr. Woods, encountering him at all. He has no memory of the majority of the night. The first thing he remembers after having drinks at a bar is waking up in the hospital.
Well, if he was cold cocked from the back, then probably wouldn't remember him.
Your Honor, I don't believe there is testimony that would allow us to come to that conclusion with certainty.
Can we credit the eyewitness testimony that the complainant was unresponsive?
I'm sorry, could you repeat that? Your
Can we take into consideration the eyewitness's testimony that the complainant was unresponsive?
Yes, Your Honor. Even taking into that account, that we don't have evidence that the cause of that unresponsiveness was the single punch.
But he was walking before the punch, and after the punch, he's unresponsive. So what do we make of that?
Your Honor, there's evidence in the hospital records that when he arrived to the hospital that he was responsive, albeit lethargic. So I would say that the evidence, there's no consistent evidence that he was unresponsive. And if he was unresponsive, that it was because of the punch that Mr. Woods allegedly threw at him, the single punch. So I see that my time has expired.
Yes.
If the court
Thank
doesn't
you.
have any more questions.
We'll hear from your adversary.
Good afternoon, Your Honors. May it please the Court. Carl Dubel for the people. I'll just quickly address the defendant's causation claim. This is nothing more than a factual disagreement with the trial court's findings. The one eyewitness to this crime testified that he saw the victim and the defendant walking up the street. He testified that he saw the defendant throw a punch and that then the victim fell and hit the ground. This testimony is completely corroborated by, one, he was able to demonstrate how this punch occurred when he was on the witness stand, and two, as Your Honor mentioned, the 911 recording, where he can be heard telling the dispatcher that the victim was punched and that he was mugged. If there's no question on causation, I'll move on to the physical injury. The victim's testimony and the photograph evidence in this case more than amply prove that the victim suffered from either impairment of health or substantial pain. The injury itself was a quarter-sized mark on his cheek, which was below his eye. It was discolored, bruised.
What should we make of the medical records, the primary diagnosis being intoxication and then the secondary diagnosis being a skin abrasion? How is that physical injury to meet for this robbery too?
So he was taken to the hospital, and most of the treatment he did receive was because of the intoxication, but obviously the hospital records indicate that he did suffer an abrasion. And the...
Well, would an abrasion in and of itself be enough to satisfy the physical injury?
It depends on how the size of the abrasion and its effect on the person. And here we have the victim's testimony where he said this abrasion lasted for 2 weeks. It didn't fully heal until that period of time. He had to take Advil for 2 weeks to combat the pain and the swelling because of the injury. And when asked the level of pain that he suffered from this injury, he qualified it as severe, which is more than trivial, and it's more than enough to qualify as physical injury.
I note that you didn't talk about the loss of consciousness. Are you claiming that the loss of consciousness is a physical injury that resulted, that was a consequence of this crime?
The loss of consciousness, Your Honor, is not our primary argument. It's more of an additional factor to consider with the nature of the attack and the nature of the injury.
Can you explain that to me?
Yes, because the victim, because he was punched and because he was rendered unconscious, and that tends to prove that the punch and the fall was more severe than just a petty slap.
Well, could it have been that he was just drunk and passed out, fell down?
Not in this case, Your Honor. There was obviously evidence that he was drunk, but there's no evidence that he was drunk. His intoxication caused him to fall, and especially given the eyewitness testimony where the eyewitness said...
Well, but the eyewitness had a few versions of what occurred, right?
Yes, he did go back and forth, but eventually, when specifically asked, he did say he saw the punch first and then the fall, and like I noted earlier, that narrative was backed up by the 911 recording.
Well, is there any evidence to show that the punch caused the loss of consciousness?
It's not 100% clear whether the loss of consciousness was caused by the punch or caused by the fall to the ground, but regardless, defendant caused both those situations. So the loss of consciousness is both potential causes would be attributable to the defendant.
Yeah.
I'll just quickly address the defense in their brief tries to minimize the the victim's testimony about the level of pain that he suffered by pointing to the medical records where the victim denied having pain in the hospital. But if you look at the times when that occurred, they were all early in the morning when he first arrived and when he was in the midst of his blackout due to his intoxication. So it's not unreasonable to believe that he wouldn't actually remember how he felt during that time period. If there's no further questions, we ask that you affirm.
Thank you.
Thank you.
Rebuttal?
Your Honor, the determination of whether physical injury is present requires an objective level of impairment of physical condition or substantial pain. That's not present here. The objective evidence is the photographs of the victim's face, the testimony of the eyewitness and the responding officers at trial, and the medical records. And I'd argue that's the most important piece of evidence as it is the most objective for medical professionals. All of that evidence shows that at best this was, as the primary diagnosis was indicated in the medical records, a skin abrasion. That doesn't rise to an objective level of physical injury that's required to elevate this to robbery in the second degree. And moreover, the victim's subjective descriptions of his pain are not compelling in this case, one, because he contradicts himself. At the hospital, he denied not once, not twice, but at least 3 times that he was not experiencing any pain. And that wasn't just in the morning when he was...
At that time, he was drunk, but that doesn't mean he didn't have residual pain, correct?
Yes, Your Honor, but I would like to note that before he was discharged in the morning when he woke up, not just when he was admitted, he was there for several hours, but that morning before he was discharged at approximately 9 a.m., he again denied pain on palpitation. So even if, his intoxication maybe caused him not to have pain, the objective evidence shows that the scrape on his face is not sufficient to constitute physical injury. The court here, the First Department, in matter of Jose B., was faced with an almost identical situation. The complainant there was hit several times on the arm, on the back, and on the shoulder. The complainant testified that he felt pain for several days thereafter, which interfered with performance of household chores. But this court said that his subjective description of his pain, his testimony, viewed in light of the objective circumstances, did not warrant an inference of physical injury.
But again, in this case, it's undisputed that there was a punch causing the victim to fall to the ground, resulting in an abrasion, resulting in him going to the hospital, and then it took 2 weeks for that abrasion to heal.
Your Honor, respectfully, I would disagree. I would first disagree that there was sufficient testimony that a punch existed. I would secondly disagree that that punch was what caused him to go to the hospital. The primary diagnosis was alcohol dependence. The medical plan was to allow him to metabolize the alcohol and then discharge him in the morning. He required no follow-up care for the abrasion. He self-administered Advil, which the complainant in that matter of Jose B. case I just mentioned did so as well. That wasn't sufficient for physical injury. So we would argue that all of the objective evidence demonstrates that this was not sufficient to constitute physical injury. We would ask that this court reduce his conviction of robbery in the second degree to robbery in the third degree and remand the case for resentencing. Thank you.
Thank you. Thank you both. Counselor, I recognize that you're here pro bono, and I want to thank you for your service, and please thank your law firm as well. Sands Brothers versus Metropolitan Paper.
May it please the court. My name is Mark Antar, and I represent the appellant, Salvatore Ziza. I have 3 points to make this afternoon. First, Supreme Court should have dismissed the fraudulent conveyance claim because Mr. Ziza was not a transferee or beneficiary of any of the fraudulent transactions here. Second, Supreme Court should have dismissed.
Was he part of a cover-up, maybe? Was your client part of a cover-up?
No, he was not part of a cover-up, but even.
So let's deal first with the $2.3 million conveyance.
Sure.
Putting aside our prior decision on it, what assurances did he give the outside auditor with respect to how he was going to handle that transfer?
Your Honor, I think it's important to understand that the claim here is that he participated, that he is engaged in a fraudulent conveyance. And a fraudulent conveyance can only be asserted against someone who is a transferee or beneficiary of the disputed funds. This court has held very, very clearly in the Cantor Fitzgerald case and in the Porco case, even participating in the transaction is not enough where there's a failure to allege that the defendant benefited or was a transferee of the cause of action of the transfer here.
So then address our prior our recent decision on this case, because we did find an issue of fact with respect to that conveyance. How do we reconcile your argument with that decision?
Your Honor, in that case, I believe that there was not clear. There was no. In this case, there has been no evidence submitted, zero, that Ziza received any of the O2 HR assets. That is not the case in the decision you're referring to. There has been absolutely no evidence submitted, and in fact, the evidence that they did submit corroborates Ziza's claims. The plaintiff's own expert, Jeffrey Johnson, submitted a report that conclusively found that that none of the funds went to Ziza. Johnson testified, it's on page 381 of the record, he could not trace the money from O2 HR back to Ziza. The report that he submitted, the expert report, barely mentions Ziza at all, except on the very first page where they just name him and they reiterate the allegations in the SEC complaint. The SEC cease and desist order. The SEC cease and desist order, which is what this entire case, that and the 2012 Huff indictment is based on, consists of allegations that Ziza did not admit or deny, and even the lower court in this case found has no probative value. And the Huff indictment does not mention Ziza at all. So I think that what makes this case unique is that even the evidence that was submitted in opposition corroborates the fact that there is zero evidence that Ziza took any of the money. And of course, by the way, Ziza submits a sworn affidavit saying he did not, which is completely unrebutted. If I may just move on to the issue of the consulting fees, which is the other fraudulent conveyance allegation. Ziza signed a consulting agreement with PSQ under which he would provide advisory consulting services to PSQ and its principal, Stephen Pence. We attacked, and the plaintiffs are claiming that the money that he received pursuant to that consulting agreement, which is part of the record, page 621 and 622, that those funds were O2 HR assets. There's no evidence of that whatsoever. Ziza's sworn statement says that the services that he provided were for fair consideration. He explained his services were needed because Pence had never been an executive of a public company before. He had no experience presiding over board meetings. He didn't even know what a chairman of a public company does. His testimony is really quite incredible on that point. And Pence's testimony is entirely consistent with the services that are outlined and the reason why Ziza was needed and hired by him. And it shows that a fraudulent conveyance does not lie against a person that takes in good faith for reasonably equivalent value. There was no evidence submitted in opposition that showed that the services were not equivalent to the value that he received. The only thing they submitted in opposition was the deposition testimony of Pence, who said, I needed Ziza, thank God he was there. I had no idea what he was doing. Ziza, I relied 100% on Ziza, who knew exactly what he was doing. The Supreme Court said that, well, I'll just move on quickly.
Yeah, because you're out of time. You will have 2 minutes on rebuttal. I know you said you had a third point to make.
I did, with respect to the aiding and abetting cause of action.
I'm going to give you 1 minute to make that point, and then
Okay.
you'll finish up on rebuttal.
Okay.
Okay?
Aiding and abetting is only where a a person provides substantial assistance and knowingly induced or participated in the breach of fiduciary duty. Here, it's important to remember, the only aiding and abetting, or the only breach of fiduciary duty that is at issue is the so-called 2010 transactions. And they say that Ziza somehow benefited or participated in Thomas Bean's breach of fiduciary duty with respect to those transactions. Ziza and Bean were on opposite sides of those deals. There were a series of transactions where Ziza's company, GEE, was acquiring different companies on site, RFP. He and Thomas Bean were adverse. And we have the deposition testimony of the attorney representing the seller saying that he had no reason to believe these were done in bad faith. These were comprehensive agreements, and the asset purchase agreements are all attached to the record, pages 429 to 586. All of it was fully reported to the SEC in 10Q forms, which are also attached to the record. These were comprehensive transactions that were done for value and in good faith. And there is, again, no evidence to rebut that. I'll save my argument on the unjust enrichment for my rebuttal.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, I'm Wallace Neal. I represent the respondents. The refrain you heard moments ago about there was no evidence presented on this or that or the other is irrelevant because none of these arguments on substance were made at the trial court. On the fraudulent conveyance claim, the only things that were argued was that it was time barred. That was it, with respect to fraudulent conveyance writ large. With respect to aiding and abetting, they went a little deeper. But on the actual, is he recipient of a fraudulent conveyance claim, that wasn't argued. So the idea that we didn't submit evidence to rebut it does nothing for the court's analysis because it wasn't presented to us. Had they presented it, we'd have had some evidence. With respect to...
Well, but how do you address that issue? So the claim is pretty simple. Hey, we didn't get any part of this $2.3 million, so you can't have a fraudulent conveyance claim against us.
Well,
How do you address that?
I think that's myopic. The allegation here is not that he got any piece of the $2.3 million, which was clearly a round trip of money. This was all post-TARP, and this was this bank trying to prop itself up by taking some of Huff's ill-gotten gains that he swept from 2,500 employee organizations, sent it out into the world, brought it back in, put a new name on it, and told the authorities in Washington that the bank was well capitalized. Set that all aside. The $2.3 million was not what he received. What he received was all of the slush fund that Huff had brought in from his $58 million heist and paid out not only Ziza, but we allege Pence and everybody else who have been involved in this. And that's another interesting point. What was mentioned a moment ago about these two people being adverse in this particular circumstance, no one was adverse here. Everyone was in on it. At this point, we've got enough evidence in the till that this whole thing was one big cabal of people who had taken $58 million and were just passing it down the daisy chain of fraudulent conveyances. And we've gone through discovery, we've gone through summary judgment. Your Honors mentioned the GEE case moments ago. GEE was the company that Pence sat on as chair of, and as to which he discussed the finances with BDO. And BDO, by the way, in this instance, had to not only disgorge money and pay a fine, but also publicly admit wrongdoing because they had clearly just taken the money and put out a bad audit. So set aside the procedural improprieties, which I submit to you are on their own dispositive, we've got plenty of evidence to prove that not only did he receive the fraudulent conveyances and aided and abetted them, but also that he aided and abetted the fiduciary duty. They make a point in their papers about the SEC order not being admissible. They put it in. It was an admission to the affirmative motion for summary judgment. They said, here's Exhibit C to Sal Ziza's affidavit. It's the SEC cease and desist order that he signed. We respond, all that does is point out issues of fact. And then on appeal, they want to say, well, it's not admissible. Well, I didn't put it in, they put it in, right? And with respect to the, and not only that, that's not the only piece of evidence we have on his affirmative acts. He also have his affirmative statement to BDO after this whole shell game went down, where he said very clearly, that $2.3 million that we paid for a CD, which we've never seen, and by the way, didn't collect interest on, even though the bank had it for 6 months. We gave the bank $2.3 million from our company into a CD, all beyond our policies in a bank that's not even insured to our levels. But we did it anyway. They gave it back to us at the end with no interest, and nobody said a word about where's our interest on this 6 months of $2.3 million deposit, right? So We submit respectfully, the evidence shows exactly what we said to the trial court, which is that there's more than sufficient case to take this to a jury. They may disagree that there's sufficient evidence that he received a benefit from the fraudulent conveyance. The trial court, Justice Barak, didn't agree, and I think the jury won't agree. But in any event, that's for the jury to decide. Unless the court has questions for me, I'll sit down. Thank you.
Thank you. All right, rebuttal?
Thank you. Just briefly, Your Honor, the issue of whether we preserve the arguments for appellate review, we absolutely did. Page 32 of the record, we make the argument very clear that there is no evidence of Ziza being a transferee or beneficiary. Ziza himself says it in his affidavit at page 49 of the record. We submit the expert report, page 597 of the record, showing that there was no assets that went to Ziza conclusively. All of this is in the record. It was said repeatedly. It was said on reply in the summary judgment motion. It was said over and over again, and we referenced it extensively in our reply brief here. There was ample evidence in the record. It was all preserved. The issue of Ziza receiving slush funds, where are the slush funds? Show me. I don't see it in the record. Where is the money that he received? It is not here. There is no evidence of it. And it's a lot of fun to talk about this crazy fraud and all these things going back and forth. Ziza never received money. That's the point. And that's the point that plaintiff's attorney refuses to answer over and over again. He says that, I'm sorry. He says that the 2010 transactions that Ziza and Bean were not adverse. These transactions were negotiated over months. In the case of the on-site acquisition, it took over a year. And then the agreement was subsequently amended. They involved, there were schedules of assets that were being purchased and other assets that were not being purchased. There were existing accounts receivables and liabilities, some of which were included, some of which were not included. The price was determined and changed and would increase if on-site and if RFFG met certain earnings targets. These are sophisticated agreements. They were all included in the record. They were all included on the summary judgment motion, and there's no, other than just the conclusory testimony that, conclusory argument that, they were all on the same team. It's very easy to say that now. I've never seen someone being adverse, someone working together on the same team when they're adverse for an entire year. I just want to quickly.
I'm going to ask, you can, one more sentence, that's it, sir.
I would just like to close then with one final thought, which is that there's no question that a fraud was committed against the plaintiffs here, but it was not a fraud committed by Ziza. Mr. Ziza demonstrated that he did not receive 1 cent from Bean or Huff or anyone else, and there's not a single piece of evidence, not a single piece of evidence suggesting that he knew that he received any money or that he even knew that a fraud was occurring. The amended complaint doesn't even allege that he knew that a fraud was occurring. All plaintiffs' arguments on appeal boil down to guilt by association.
Thank
and that
you.
is enough. That is not enough to defeat summary judgment. Thank you, Your Honor.
Okay, 14 East 4th Street against Toporek. Judge Singh is recused from this matter.
Good afternoon, Your Honors.
You can proceed.
Thank you. My name is Bryce Jones, Jones Law Firm, PC, or the defendant appellant, Michael Toporek.
So we have the new rent statute that's at issue here, correct?
Yeah, that's correct, Your
Two
Honor.
different provisions that apparently we need to consider. Let's start with the mitigation provision. Why wasn't, as the lower court said, the affidavit and the exhibits that were presented by the landlord prima facie evidence that they did what was, I guess the standard is commercially reasonable regarding the mitigation in this case when your clients moved out?
So the answer to that, Your Honor, is twofold. First of all, this was not an issue for summary judgment. A reasonable jury could have found that the mitigation statute was not
Well, I don't understand what that means, because the analysis on summary judgment is that one side makes a prima facie case. If they don't, then it's denied. If they do, then you have to raise an issue of fact, correct?
The issue of, correct, Your
That's
Honor.
the paradigm.
Right. The issue of fact is
Yeah.
whether they took actions that were reasonable to comply with the statute by renting the apartment at the lower of the fair market value or the then existing lease rent. So our argument is that you can take all the actions in the world, you can take out a billboard in Times Square, but it doesn't matter if the rent that you're listing it for is higher than the existing lease rent. So the only two...
How do, if at all, rent concessions figure into that?
So I think there are two ways. One, there's a factual question of whether any rent concessions were actually advertised or offered.
Well, why do they have to be advertised if they're otherwise going to be provided? I mean, I guess part of the problem that I have with your arguments is that there's no evidence on your side. So then I look at the landlord's side and I think to myself, did they make out a prima facie case? That's really the key question here, because you don't raise anything in opposition.
Right. So, Your Honor, the reason we did not bring our own affidavit is because all evidence of mitigation at this stage is within the possession of the landlord.
That's absolutely not true. But
We could have done discovery.
You are relying on you are relying on whether they made a prima facie case or not. And quite frankly, the reason doesn't really make much of a difference in terms of the analysis. But I don't believe that's true, sir. But
okay. Well, our argument is that they did not present evidence that there were actually rent concessions ever offered to anyone. We didn't have the opportunity to do discovery, to see, or to even cross-examine the affiant to see if these rent concessions were actually offered to anyone. The question of whether they were ever offered, and if they were offered, let's presume that they were offered for a moment, was that at the lower of the current rent or fair market value?
well, they did provide what they say were comparable apartments and their rents. You didn't provide anything else of comparable apartments that were at lower rents than your client was renting, did you?
We did not provide any other
That was
apartments.
available to you, though.
There
Sure, the
are
listings.
the multiple listing service would have had closed listings, but we were
Or
never
open
allowed.
listings. You could have gone on Street Easy too, right?
Well, we could have with discovery or with an expert witness
Without
presented a broker.
discovery, I could go on Street Easy tomorrow and look for
Right, but
apartments
Street
within
Easy-
a certain price range or a neighborhood. Anybody can.
So, Your Honor, on Street Easy, which I used in the last couple of weeks to find an apartment, they list net effective rent when it's provided by the landlord. When there are discounts, it's on there.
You didn't provide that in your papers, though.
Our argument is that net.
And in their papers, they provide an explanation. I mean, I guess the problem that I'm having is, if you can tell me, and I think that's fair game, an argument as to why they didn't make out a prima facie case, then they don't get summary judgment.
There is a presumption based on the fact that the apartment did not rent out for months, that the landlord did not advertise it low enough or did not
Where
offer
is
it
that
for low enough.
presumption?
I'm sorry?
Is that a statutory presumption? Is that in the statute?
The case law that we cited from the bankruptcy court in this southern district, where there are prior, in the bankruptcy world, there are often issues of mitigation that come up. So there is case law that says that it can be a rebuttable presumption. And I think that's a question, again, of fact.
I know I'm asking you hard questions because I think these are hard issues on a new statute. Where is there an evidentiary presumption that in mitigation cases?
The burden of proof, the statute gives the burden of proof to the landlord, which means that we have to establish for all the cases going forward, based on this statute, what does the landlord have to do? So if the landlord can advertise for rent and just say an affidavit, by affidavit, we offered it with concessions, that is not sufficient. We should have further fact-finding. We should have the opportunity for cross-examination. These are issues of credibility. We should have the opportunity to try to find who are these people who were ever offered concession of rents. And none of that was ever done. So you know, there is an inference that not renting something out for 5 months means you didn't price it low enough. If you showed it to 60 people and they didn't take it.
But you're saying it's a legal inference. That doesn't change their...
It's a factual inference.
I understand your argument. I don't know if I agree with it, but I understand it. Okay, you'll talk about the security deposit on rebuttal, okay? Because that's a separate, otherwise important issue under the statute.
Yes, Your Honor. Thank you.
Okay, thank you.
Good afternoon, Your Honors. May it please the court. My name is Matthew Ullman, attorney for respondent. This is my first time arguing in front of any appellate court, so I thank the court for its time.
Well, let me ask you a question. I think this is an important case because it involves a new statute. So we always had mitigation as a matter of law. That was common law in residential apartments, not commercial. So the statute then codified that, correct?
Absolutely, Your Honor.
And it added some otherwise different stringent requirements that were supposed to be put on the landlord, correct?
I don't know that I would argue that they were different. I would argue that...
Well, certainly they were different because here you had to, there's a specific requirement that the mitigation involves you marketing the apartment for the lower of the fair market value of what the rent would be otherwise, or the rent that was actually charged the tenant under the lease.
Yes, and...
That's a new requirement, correct?
Well, if you look at Chupak versus Gomez, Your Honor, which was in 2017 from this court, it was, the issue in that case was, again, mitigation, although that was in the defense and prior to RPL 227E. But in that case, which was significant to the facts here, the landlord was required to show that it mitigated its damages in a reasonable way because that's what the defense of mitigation of damages required. And this court specifically held that marketing the apartment for rent after finding out that the tenant had vacated was reasonable as a matter of law. In fact, all of the cases that were cited by Appellate...
And the statute doesn't change that as to what's reasonable? It doesn't add additional requirements on the landlord?
That it has to be at the lower of the fair market value or what was done. And we did that here. If you look at the record at page 150, Appellant ignores the fact that the lease that was provided, that was given to the next tenant, was in fact at $16,500, which was lower than the amount that was rented to Appellant. That's in the record.
And how does that prove that during the applicable period, which was until October of that time, that those rent concessions were being offered? How do we know?
Because the affidavit that was provided by the principal states that it was provided at a net value of $16,500, which was lower than the rent provided by Appellant.
But other than that affidavit, which some might say would be self-serving, what other proof? The advertisements listed significantly higher.
I understand that, Justice Pitt, and I can appreciate that concern. However, we do believe that the lease that was provided as supports the affidavit. It's not just that the principal made these statements without any kind of evidentiary backing. In fact, what was provided was the lease, which in fact states on page 150 that there was a concession of 1 month. When provided in conjunction with the affidavit, it supports the contention from Ms. Isikoff that this was being offered at a net effective rent. Not only that, but there was absolutely no affidavits provided by appellant in response to any of these statements. As Justice Gish, as you pointed out earlier, there was absolutely nothing in the record that contests not only what was being marketed, not only that it was being offered at the lower rent, not that it was being marketed shortly after appellant improperly vacated during the COVID pandemic, but there was just no support in this affidavit. There was no affidavit. It was an affirmation, a conclusory affirmation, which is improper.
So is there, to your understanding, any presumption that's applied because you did not re-rent the apartment, even with marketing, at during the applicable period?
And no, and thank you, Justice Gish, because actually the cases that were cited...
I was going to say, don't thank me. You don't know which way I'm going on this yet, but go ahead.
Well,
I want to hear what you have to say about it.
Sure, and if you look at, besides Chupak, which we believe is obviously not precedent, but is supportive from the first apartment, if you look at the cases that were cited out of all of the districts, Connecticut, New Jersey, Iowa, Colorado, they all stand for the same proposition. And that proposition is that when I'm sorry, I see my time is up, Justice Gish.
Yeah, just finish that answer. And I actually have one further question to ask you before we hear from your adversary.
Of course. The proposition is very simple, right? The proposition, and this is from the Iowa court of J.M. Grimstad, is that a landlord cannot sit passively by. And those are the words of the Iowa court, which is cited by appellant in support of their position. A landlord cannot sit idly by and do nothing. So the courts out of Connecticut and Iowa, New Jersey, all of which require reasonableness from the landlord, suggest that marketing the property, not selling the property as a caveat in Iowa, but that marketing the property is sufficient in determining whether a landlord has properly mitigated its damages, because it's not sitting passively by. So the argument that landlord is making, that 9 months is somehow insufficient, is his opinion, and is not even supported by the case law of which he provides.
All right, now I want to just ask you a question about the security deposit statute. And I want you to assume, and we're not deciding this, I know you make an argument that you were totally in compliance with that statute. But if you're not in compliance with that statute and you keep the security deposit, what is the remedy?
Under General Obligations Law 7-108.
Right, correct, under the new statute.
Well, 1-AD is different than 1-AE. 1-AD, which is withholding the security deposit, requires that if we do not provide, 1-AE provides that if we do not give the notice of 14 days, correct, then they get the security deposit back.
Correct.
But appellant has already admitted in his papers.
No, leave that aside. I understand you making that argument, but let's assume you didn't comply with it. What's the remedy?
The remedy would be that in this hypothetical situation of which we disagree, that we feel that the record disagrees with.
Your record is preserved.
Thank you, Your Honor. Is presumably they would get the security deposit back, but they were not able to show that we purposely withheld.
But purposely, doesn't that only go to the punitive damages part of it?
Correct.
The willfulness.
Right.
That doesn't allow you to hold back the security deposit if you've otherwise taken it in violation of the statute. The remedy is forfeiture, isn't it?
The remedy is forfeiture, not punitive. Yes, that's what we suggest.
All right. Thank you. You've answered my question.
I'm sorry. Thank you, Your Honor.
Honestly, we have your briefs, so I don't want you to think we're discounting the other arguments. I think it's an important argument that both of you are making.
Thank you for your time.
Okay.
Your Honor,
Okay, Counselor, the security deposit, what's going on with that?
So I'd like to address the last question that you asked, Respondents' Counsel. I believe the remedy is that you cannot seek damages if you're the landlord for damage to the apartment if you don't offer a pre-move-out inspection. We have to think about the implications for all the
It would
tenants in the
almost
city.
be, well, the statute calls for forfeiture of the security deposit, but if you were allowed to sue for damages, wouldn't that be an end run around the statute?
That's our argument entirely, Your Honor. So otherwise, if the statute is to have any force or effect, then if you say that the landlord did what they said they did, they sent a letter, they never offered the pre-move-out inspection by Zoom or FaceTime or otherwise, then that's sufficient evidence to grant summary judgment on the security deposit issue, which in effect means summary judgment on the issue of damage to the apartment for the appellant. And so for that reason, we'd say to reverse.
And the remedy also carries with it not just the return of the security deposit, but the possibility of punitive damages under the statute, correct?
That's correct, Your Honor. So the question there is whether it's willful or not. And in this instance, the remedy is complicated somewhat by the question of May rent, which our client said the security deposit should apply towards May rent.
Well, the lease said you couldn't do that, and the security deposit law doesn't say you could do that either.
Sure. So then there's a question of whether punitive damages are appropriate or not. That should certainly be decided by the jury, if not on summary judgment.
Probably, or the trial court.
Or the trial court, yeah.
Yeah. I mean, I'm considering it. I'm thinking about
Yeah,
it.
the question is whether the statute has any teeth at all, Your Honor, and I'll wrap up. What is the consequence of not complying with the letters of the statute? Do you get to just completely ignore it and not give notice of the pre-move-out inspection, or is there any consequence? At a minimum, there ought to be sort of like a spoliation inference at trial that you've denied the court, the fact finder, of the ability to have the evidence that would have been there if you had done a pre-move-out inspection together, because there would have been an interaction between the landlord and the tenant, and there would be evidence of that, presumably video evidence.
Okay. All right, thank you. Thank you both. Mateo versus Ionelli Construction.
Good afternoon. May it please the court. Patrick Lawless for the defendant appellant, who respectfully requests that this court reverse the order of the Supreme Court which granted the plaintiff partial summary judgment on Labor Law 241, subsection 6, based upon a violation of Industrial Code Section 23-1.7E2. It's undisputed that at the time of the accident, the plaintiff and his coworkers were involved in demolition work. It's also undisputed that the ductwork which the plaintiff was attempting to climb over at the time of the accident was a result of this demolition work and was integral to the work.
How long had that air duct been on the floor?
According to the plaintiff's testimony, it had been there around 15 minutes because his coworkers that were removing the ductwork and himself all went on a break, and he testified that he fully expected at the end of the break that it was typical when the break starts, everybody stops what they're doing, they take their break, and then they immediately come back and continue what they were working on. He said this was normal, and he fully expected that when his coworkers returned, that they would continue with their work.
Counsel, did you raise this argument for the first time in reply below, or had you put plaintiff on notice that this was really your...
Well, it was in reply, but also in opposition to the plaintiff's cross motion for summary judgment, and the plaintiff submitted a reply, so the plaintiff had an opportunity to have the last word and address this argument, so it was properly, it's our contention, it was properly before.
So you raised it in opposition to plaintiff's motion?
It was in opposition to the plaintiff's...
By citation, right? Not by, is that how you raised it?
I'm sorry?
It was by citation, your argument on the integral whether or not
Yeah,
it's
yeah, that
integral
it's,
or not.
yeah, that it's integral based upon decisions from this court as recently, this past April, in a Torres decision. This court said that when the debris that the plaintiff allegedly tripped over was integral to the work, that there's no violation of the industrial code. In this case, the plaintiff didn't even trip over the debris. The plaintiff attempted to climb over it. So we feel that the facts of this case are even stronger, and at the very least required denial of the plaintiff's cross motion for summary judgment, if not granting us summary judgment dismissing that claim. And with respect to the plaintiff's 200 cause of action, it's undisputed that that Ionelli didn't exercise sufficient control and supervision over the plaintiff, assuming that and it's our position that it arose out of the plaintiff's work. But even if the plaintiff attempts to claim that this was a dangerous condition, number one, there's an issue of fact whether it even constituted a dangerous condition, whether it was open and obvious and not inherently dangerous. And number two, that there wasn't sufficient constructive notice of it because it only existed for 15 minutes.
Isn't this more means and methods in dangerous condition?
I'm sorry?
Isn't this more a means and methods case than dangerous condition?
It's definitely a means and methods case. That's our position, that this was the means and methods of the work, and that based upon that, the 200 claim should have been dismissed because there wasn't sufficient supervision and control. Thank you.
Thank you. You can proceed.
Thank you. May it please the court, Paul Scatroma on behalf of the plaintiff, Joseph Mateo. Mr. Mateo would ask the court to affirm the decision of the court below for the following reasons. The first being that this duct that was taken down in the course of demolition was not integral to the work being performed.
Was the duct part
Yes,
of the demolition?
The duct had been removed.
Well, but was it part of the demolition project? Was it part of the demolition project, sir?
Yes, sir.
Okay. What was going to occur to the duct once it was placed on the ground?
It was supposed to be disposed of.
It was supposed to be chopped up by the demolition crew and then put in the dumpster?
Correct.
So based on those facts, why is the duct not integral to the demolition work?
It's my understanding, Your Honor, of the case law that integral to the work being performed is the concept of you need it to accomplish the task that you're doing. So once the duct is taken down, it's debris. The fact that it's supposed to be taken out and removed and disposed of, it's not integral to the work anymore. The work has already been accomplished. It's been removed. If you were to accept my adversary's definition of incident to the work, there would be no purpose of the industrial code provision involved here because everything would be incidental to the work, tools, debris, whatever. And I would also appreciate reminding the court that there is no testimony in the record when that particular duct was taken down. The only testimony from plaintiff's deposition on, I believe, pages 190 and 191 was that he was working, demolishing a separate room in the basement, and other people were removing ductwork. He never even testified he saw the people who removed this duct. The record is silent regarding when this specific duct was removed.
There were no other contractors on the premises, though. His company, the company that plaintiff worked for, was responsible for the removal of the ductwork.
That's correct, Your Honor.
Does that make a difference?
I don't think so under the industrial code. Judge Suarez below based his decision of liability pursuant to 27-1.7E2 on the fact that it's not a question of whether the duct the plaintiff tripped over the dock or slipped over it, or as the defendant claims fell. Judge Suarez looked at the entire scene, and the entire scene was the passageway to the bathroom, which was the only bathroom available to the plaintiff.
You know, Counselor, we can actually hear you better if you are by the microphone.
Thank you, Your Honor.
I know we may look like a jury, but we're not.
The issue was
Yeah,
that.
and if you bring the mic down a little bit, right.
Thank you, Your Honor.
With these masks, the acoustics.
It'd be nice if I could be heard. It's not a question, according to the decision below, whether plaintiff tripped or slipped. The issue is the only path he had to get to a bathroom, because the bathrooms outside were blocked by excavation, was he had to go either over the duct that had been removed, and there's no testimony. That's why the Labor Law 200 issue was decided against defendants.
Okay, so let's talk about the 200 issue. Your adversary says this is a means and method. There's demolition work going on. The duct is taken down and then deliberately placed on the floor, where it's going to be chopped up, put in the dumpster. Why is that a defective condition as opposed to means and methods of the work being performed by the demolition company?
I think they created that dangerous condition by the work they performed. In other words, they performed half the job. They removed the duct, and as plaintiff testified in his deposition testimony on pages 190 and 191, I'm sorry, they're supposed to remove it as soon as it's taken down. They didn't do that. They created this dangerous condition, and when plaintiff tried to get over it, that's when he fell. Thank you for your attention.
Thank you. Rebuttal?
Just very briefly, pursuant to this court's decisions, again, a recent decision in Torres and Solis, which is also cited in our brief, that this type of debris is considered integral to the work. And
that's because debris removal was part of the work.
Exactly. That was the purpose of the work, was to remove the ductwork and to remove the debris. Even the plaintiff's testimony that there was other debris, he said it was sheetrock and brick from the walls that they were demolishing. That's all that was there. They were the only ones performing the work there. And the sole case that the court below cited in support of his decision actually supports why this is not a 241-6 case. The case that the court below cited is called Licata, and in that case, there was testimony that the debris, now the plaintiff didn't trip on it, but the debris was food wrappers and other refuse and garbage, basically, and that it obscured a hole that he stepped in. That's not the case here. The case here is that every bit of debris, the ductwork and the debris that the plaintiff is talking about, was the purpose of the job, was to be demolished and to be removed. And unless you have any further questions, I'll...
Thank you.
Thank you.
Hamel versus Park Avenue Armory, please step up.
Good afternoon, Your Honors. May it please the Court. I'm Matthew Corcoran, attorney for the Appellant Lighting Syndicate. It's our position that the decision of Justice Billings in the Supreme Court, New York County, should be overturned because there are several key case laws that note that the evidence in the record shows Lighting Syndicate should be obviated of any liability for this accident. Now, first and foremost, we argue that Lighting Syndicate, as a laborer, followed all the plans and specifications that were laid forth and created, approved, drafted by all.
So let me stop you there.
Sure.
How was that shown? Well, first, are the specifications in the record?
They are not, Your Honor.
Okay, so then how have you shown through your witness, I think it's Mr. Heinreich, that the specifications were followed, plans and specifications were followed?
Well, we argue it's shown through the testimony of the other parties. It's shown through the testimony of Armory's Paul King, which says Lighting Syndicate did everything that they were asked to do with respect to hanging lighting, with respect to laying down the stage, constructing the stage, fabricating the stage, or excuse me, assembling the stage, and laying down the flooring. He confirms that everything was done in accord with the plans that were submitted to the New York City Department of Buildings, which were permitted. I believe that testimony in and of itself establishes that they followed the plans. He says that the plans or the work was done according to the building code and according to the permitted plans.
Were those plans submitted to the court below?
I don't believe they were, no, Your Honor. Secondly, there's
So how
also
was
case
the
law
court
that
to
states
know that the
I'm so
work that
sorry.
was done by the defendant was actually in accordance with the plans?
I'm sorry, the defendant.
How was the court below to know that the work done by this defendant was actually in accordance with the plans and specifications?
Based on, like I said, the testimony of the other parties, specifically Paul King, who testified explicitly that Lighting Syndicate did all of their work in accord with the plans that were submitted to the New York City Department of Buildings.
Go ahead.
Additionally, there's case law that says that after-the-fact inspections performed by the other parties and the parties who hired Lighting Syndicate, showing that the work was approved, also obviates a contractor of any third-party liability.
Well, isn't there another basis for liability that the court denied summary judgment on? She said that without the plans, there is no way to figure whether the plans and specifications were apparently deficient, that they would have put your client as a contractor of ordinary prudence on notice that the work created a dangerous condition.
And
How can we make that kind of conclusion here?
I would cite to the cases in my brief, Ryan versus Feeney and Diaz versus Vasquez, both of which state that the responsibility to show that the plans were free of defect is not on the contractor. Diaz versus Vasquez very explicitly stated that that contractor was permitted to rely on the fact that the other parties prepared the plans, and that in that case also a municipal entity signed off on the plans and permitted them. Lighting Syndicate is allowed to rely on that. Diaz versus Vasquez says it's on the parties in opposition to show there was a defect in the plans.
Sir, separate from the alleged compliance with the plan, isn't there another issue where lighting actually was actively involved in dealing with lighting, no pun intended, that there was an argument that they launched a force of harm in addressing the stage lighting and operating it?
Well, again, the lights were not just the fabrication of the stage, but the lights themselves were also part of the plans of Armory's independent contractor, Mimi Jordan Sharon, which Paul King and other parties also testified. She directed their work. She told them, this is where I want the lights, this is where I want them facing, this is the level I want the lights at.
Well, but I think what my colleague is getting at is before the actual staging, didn't your light board operator had the ability to make it a little lighter so people could see their way around the stage?
No, in fact, he didn't, Your Honor, and that's testified to by both Jacob Heinrichs and Courtney Caldwell, the Armory's house manager. They say that the light board is basically just switches. They have no ability to change the direction of the lights. They have no ability to change the direction of the lights.
What, if you turn on a switch, there's more light, no?
But my client is also just a subcontractor following the direction of their employer, Mimi Jordan Sharon and the Armory. They didn't have any independent authority, as also testified to by Paul King, to mess with the lighting design. Paul King explicitly said Lighting Syndicate had no hand in changing the lighting design as set by the designers and the Armory's production staff. And just briefly, I do want to point out one more thing because I know notice is also an element in this case. There are several other issues. Paul King also confirmed there's no written maintenance agreement, and there's no argument Lighting Syndicate was neither an owner or a manager of this property. So without a maintenance agreement, they have no duty to warn, inspect, or repair any defect on this property.
All right, you'll have some time in rebuttal.
Thank you, Your Honor.
Thank you. Okay.
Good afternoon. May it please the court. My name is Elliot Zucker from Aronson, Rappaport, Feinstein, and Deutsch on behalf of the plaintiff respondent. This appeal, in our view, is simply about the burden of proof and what the movement has to show the court.
So your adversary argues to us, and it seems like a reasonable argument, is that essentially everybody accepted the work. There were no issues by other parties with respect to whether or not lighting had completed the work in accordance to the specifications. Why isn't that a good argument?
Well, look, let's look at the proof that was actually before the court, okay? They have a witness who admittedly has no knowledge. They don't produce affidavits as required by the statute. that has, of anyone with knowledge.
But they refer to other parties.
What they refer to is basically 3 questions by Mr. King, where Mr. King gives 3 one-word answers. Yes, yes, yes. That's their motion. You know, they have no documentary proof. We know the plans
Is that an
exist.
admission? Is that an admission by the party that, in fact, the work was done in accordance with specifications?
The questions are so non-specific, it's hard for me to judge that, and I think it's hard to decide that summary judgment is warranted on those 3 one-word answers. Okay? And again, this is a defendant who could have produced the evidence. You know, they're directed by the court 3 times to do so and failed to do so. They could have done more. They could have met their burden. Again, we don't think that you can get summary judgment on those 3.
So that's one
yes
issue.
answers.
The other issue is with respect to the obligations of the light board operator. They say, you know, we were following orders in terms of how we lit it up, and we had no choice in the matter.
Well, look, you know, there's a number of problems here stemming from the failure to produce somebody with knowledge. Okay, we know the judge's own decision refers to it, that there were other incidents in which audience members were injured trying to traverse the stage. Okay, what knowledge did they have of that? We don't know because they never produced anyone with knowledge, and that might affect the determination of whether or not they could have done anything. You know, we also have an unrebutted expert affidavit. Again, why couldn't they have come up with an expert affidavit? This expert affidavit says this is essentially a patently dangerous condition. No rebuttal at all. That by itself, what I would argue, creates a question of fact. There's no other questions?
Any questions? Oh,
Thank you.
Thank you.
Your Honors, may it please the court, my name is Andrew Kaufman. I represent the Park Avenue Armory. The plaintiff testified at pages 354 through 366 of the record that when she entered the portion of the theater where the play was, there were no lights on. Mr. Heinrichs, the silent partner of the company, had no knowledge of any of the activities. He attended one of several meetings at the Park Avenue Armory. He had no personal knowledge of any of the activities of his staff at the Park Avenue Armory. During discovery and his deposition, we elicited that there were 9 people who had knowledge, including his other partner, Doug Philomena, Sean Linehan, who was involved with the electrical, Evan Purcell, Abby Walsh, Bethany Taylor, and others. I obtained 3 court orders for discovery related to these people. I got no response from the lighting syndicate. There were no affidavits or depositions.
Was there an admission that the specifications were met by lighting?
Was it an admission?
Was there an admission in the record? Is there an admission in the record?
Mr. King testified that they followed whatever the plans were. However, the person who was in charge of the lighting, Mimi Sharon, was gone after the first few days. It was the lighting syndicate who was operating the light board continuously through the show. There was testimony that there had been accidents because of lighting issues. Mr. Heinrichs could not identify the amount of lighting that was provided at the time of the plaintiff's accident. He certainly had no personal knowledge. The lighting syndicate failed to satisfy CPOR 3212B that requires a person with knowledge to come forward with evidence. Justice Billings' order that denied their motion should be affirmed based on those issues. If the court has any further questions, I rely on my brief.
Thank you. All right, Syndicate Lighting, some rebuttal, please.
So before I begin, I do just want to point out that counsel for Armory did admit before the court that his own witness testified my client followed the plans. Beyond that, the outstanding discovery issue, as noticed by Justice
I think what was suggested is that it was very conclusory and very general and not sufficient for us to make a finding as a matter of law. I think that would be the argument, no?
Well, no, I mean, I don't agree with, and I believe it was plaintiff's counsel who brought up that it was 3 very conclusory questions that were asked of Mr. Paul King as to whether or not my client followed the plans. He was asked numerous questions about that. Not only that, William Gorlin, on behalf of McLaren Engineering, testified that he'd inspected the stage and that it was all in compliance. There was an inspection which was noted by plaintiff's own expert, by Kevin Byrne Architects, which said that the work was done in compliance with the plans. And another employee of the Armory, Wayne Lowry, also testified that the New York City Fire Department came in.
What about the work, the lighting during the actual performance? If you had people there who were actually there, how come there's no affidavit or anything from them indicating that they had no ability to change the lights or bring up the lights in the house?
I agree that it is unfortunate, but as Justice Billings
More
also...
than unfortunate, I really want to know what legal significance it has.
Well, I think that without an order compelling it or precluding my client from offering testimony or striking my client's answer, I think that since plaintiff filed the note of issue, nobody else made any motion to compel my client to do that. I think we have the evidence in the case that we have. And I think that that's what we have to work with, including that's what they have, and it's their client's testimony regarding that. So yes, Jacob Heinrichs, I admit, didn't have personal knowledge of that, but as Justice Billings also pointed out, nobody made any effort outside of putting an order in a couple
So then how did you make a prima facie with respect to at least the second theory of liability, that the lighting before the show was too dark?
Well, if I may, there's a somewhat related point that I have on that, and that was also brought up by one of my respondents, that Armory was put on notice that there were some people, and I'll just finish this point, please.
You may.
Armory was put on notice that there were people who were having tripping incidents on the stage prior to Ms. Hamill's incident. And she testified, that's Courtney Caldwell, the house manager, that she got together with other members of the Armory's production team without Lighting Syndicate. They decided to increase the lighting without any input from Lighting Syndicate. And there is case law I cite to Rappaport versus DS and Deland that states when the owner has notice of a defect on a property, a subcontractor who works there cannot be held liable for that. And here it's very clear. Courtney Caldwell testifies. They knew people were tripping. They tried to address it.
But we don't know what you did or your light board operator did on the night of the incident. And the assertion is that it was actually dark.
Unfortunately, Your Honor, yes, that's where we are in the case. And just to conclude that one point, once again, Courtney Caldwell testifies that she'd gotten together with the Armory production staff, and not only that, as the person who was responsible for training and placing ushers, she also testified that after those prior incidents, they did nothing to place new ushers, hire new ushers, or move ushers around to help people take the stage.
Well, that may be relevant to their liability, but it doesn't exclude your liability. But okay, I think we understand your arguments. Thank you.
Thank you.
People versus Esperanza.
Good afternoon, Your Honors. May it please the Court. My name is Cara Labini for Maria Esperanza. In its response to defense counsel's suppression motion, the prosecution carefully avoided the dispositive fact alleged, which was that Mrs. Esperanza did not consent to the police's entry of her apartment. Because the prosecution did not argue that consent was immaterial, the question remained open. A hearing cannot be summarily denied in those circumstances. To properly deny the motion, the court had to know the timeline of when the warrant was granted vis-a-vis the initial entry of Mrs. Esperanza's apartment. The defense did not know this, the court did not know this, but the prosecution did. The prosecution omitted the initial entry entirely in its response motion, thus obscuring the facts from the court, and misleading the court into thinking that there was a warrant when the police entered the apartment and found the drugs, when in fact there was not. I'll address, I'd really love to hear your questions if you have any, but I'm happy to go on.
I have a question. Let's say that they entered without her consent, but the police later got a warrant and they search the premises and they find the baggie of heroin on the bathroom floor. What is the result of them having entered without a warrant if they ultimately got a warrant later and were able to search?
So you're referencing the independent source doctrine, I believe, is that correct?
Yes.
Yeah, so those facts should be litigated at a hearing where if the prosecution wants to contest the fact that the warrant was an untainted source for the drugs, they may. The burden is on the prosecution at such a hearing to argue those facts. And I think this court's decision in Marinas controls that question entirely. And in that case, this court held that where the police are applying for permission to enter an apartment and to search for evidence that they already have and have in fact already entered an apartment, the warrant is clearly a tainted source. But again, that should be litigated at a hearing where facts can be elicited and the police's credibility and motivations can be probed by both parties.
Did you raise below this issue that there was a search of the apartment before the warrant was obtained in any fashion, in a general way, sufficient?
So what was brought below was that there was no consent to the entry. Mrs. Esperanza did not know that the police didn't have a warrant. She is a 67-year-old non-English speaker who had never before been arrested, who was a diabetic and did not even leave the house by herself without the company of a family member or friend. She did not know, and we know that she did not know because defense counsel not only requested a Map Dunaway hearing, but moved to controvert the search warrant in this case. We also know that she did not know because of trial testimony in which Mrs. Esperanza said she didn't really know how long the police were there. She thought it was about 30 minutes. So clearly her perception of the timeline was not fully accurate. And in that circumstance, we can't expect the defendant to know. We can expect the prosecution to know those facts and to air them in a response motion. They were very careful here. They took pains to sort of skirt the issue of consent. They interposed the use of a drug detector dog between a timeline, sort of between facts that were known prior to the police, prior to the warrant's issuance, sort of like indicating that they did have a warrant when they initially entered, knowing full well that there were two entries. There was initial warrantless, consentless entry.
With respect to the initial entry, would it have been permissible to, quote-unquote, freeze the premises?
Yes, Your Honor, I believe so, and that was alleged in the search warrant affidavit in which the police said the premise.
So why is a hearing necessary if you're saying that that they could enter to freeze the premises, only to freeze the premises, not to search?
Well, freezing the premises could be done by police waiting outside the door or by entering. So are you asking whether it was permissible for them to enter
and freeze the premises
without her consent? Absolutely not, because they did not have a warrant. And we have no facts. The prosecution has not met its burden as to the independent source doctrine.
So in this context, to freeze the premises before obtaining the warrant would be to leave someone at the front of the door to the premises and not allow anyone to enter or exit. That would be the freezing of the premises in this.
I mean, it depends. I had another case in front of Your Honor where the police froze the apartment without alerting anyone inside the apartment that they were doing so. Here, the police alleged in the search warrant affidavit that they knocked on the door, that there was one person home, and that that person could destroy evidence, which clearly she could not have because the police were actually in her apartment. So we have the prosecution misleading the court, we have the police misleading the warrant court as to what they were, whether they were actually in the apartment and found the drugs. And in that circumstance, we shouldn't expect the defense to know facts. As Your Honor, Justice Gish said in a previous case, a suppression motion these are just pleadings we're talking about. We can't expect the defendant to know all the facts at the prosecution's disposal when they just don't have them. And I think that is supported by Mendoza and Hightower, which is which are both cited in our briefs, of course, as well as several other cases. Unless there are other questions, I will reserve the rest of my time for rebuttal.
Thank you.
Thank you.
Good afternoon, Your Honors. Diana Wang for the people. Defendant did not preserve her claim because she never argued below that there was a pre-warrant search. And for the same reasons, she did not set forth a factual
But how would she know that? How is she to know, at least based on the rendition by your adversary, woman who doesn't speak English, health issues in her 60s, never been arrested before? How would she know that? Well, isn't it your obligation to give a timeline to the court, for the court to be able to independently decide whether or not a hearing is necessary?
It is defendant's initial obligation to set forth
And
at
so
least
as I
factual
understand it,
allegations.
defendant said no consent to enter the premises.
But that is not the same as saying there was two searches, one pre-warrant and one after the warrant.
But in the omnibus motion, the defendant indicated that there was no consent to search, right? And wouldn't that is, at that point is enough? Then the people have to come back and say, well, this is what happened, this is what happened, not necessarily omitting the fact that there was, in fact, a first entry and then a post-warrant entry, right?
The people, first of all, did not omit anything because there's only one entry. They entered at 6 p.m. Defendant knew that, English or not, she knows that they entered at 6 p.m. And before she filed her omnibus motion, defendant's counsel had a copy of the search warrant which said it was authorized at 8:30 p.m.
But I don't understand why no consent wouldn't put you on notice, because if the warrant allowed you to get in, then you didn't need consent. So if the defendant is saying no consent, she's talking about something else, right?
No, Your Honor, because the way the omnibus motion reads, she says, I didn't consent to a search. In a separate section, she says, if the search was conducted pursuant to a search warrant, that search warrant is defective. So basically, she's saying these two categories precludes all valid searches. So the people responded by saying, I don't need to talk about consent because I had a valid search warrant. And then the people defended the search warrant.
The first category. It just addresses the second category.
It doesn't, it obviates the first category because.
Well, or one can say, well, it conveniently ignores the first category, right?
Well, defendant's claim didn't put the people on notice that not only am I talking about.
You know the facts. You know the facts.
So did defendant.
You've interviewed the police. You know exactly what happened, when the police went in, what they did. No?
Yes, but so
and
did
you
defendant.
don't have an obligation under those circumstances to put the court on notice, because from the decision, it appears the court just believed there was a warrant, search was made, everything is fine.
No, because the people actually did say, here is a search warrant. The court had a copy of the search warrant. The search warrant said it was authorized at 8:30 p.m. Oh, and the people's response also said, oh, by the way, we have frozen the premises in applying for the search warrant. So,
But did they say that they were inside the premises when the premises were frozen?
no, Your Honor, but it's a reasonable inference because.
Not really, right? Because as your adversary indicates, and in many other situations, premises can be frozen from the outside. And if people approach the door, no, you can't go in, right?
But this is a buy and bust case where the baggies of drugs are small and they are susceptible to being flushed down the toilet or being thrown out of the window, and that's exactly what the officers
So you
did.
have the right under those circumstances, assuming for argument's sake that the defendant didn't consent to the entry, to enter the premises?
Yes, because exigent circumstances called for the officers to enter the premises.
Were those allegations made anywhere below, or is this just argument you're making now?
That was revealed at trial, but only because.
But not in the motion papers, right?
Right, but only because defendant did not put the court or the people on notice that she's not just talking about consent.
But we get back to the idea, she said no consent, and you're arguing here, yes, we could go in because of exigent circumstances with or without consent. So you knew you went in the premises before the warrant was obtained, correct?
Yes.
All right, and you're now claiming we went in because of exigent circumstances, or otherwise, it's just hard to understand how you reconcile her claim of no consent with not understanding that you have to fully disclose how you got into the premises, why you were in the premises, and your legal authority for doing so.
The people disclosed that it was subject to a search warrant, that the search warrant authorized the search.
But the
There's
search
only-
warrant was not issued until they had been in the apartment for 2 hours.
And defendant knew that. She knew that they entered at 6 and that the search warrant was authorized at 8:30.
Did they say to her, hey, just hold on a second, we're going to get a search warrant?
But that was her burden to make that allegation before the motion court. If
She didn't consent. That's what she said, no consent. I didn't consent to any of this. No consent.
That implies there's one search, and she's basically saying, I didn't consent, and to the extent that consent was not needed because of a search warrant, that search warrant was defective. She's trying to cover all her bases, but that does not
Why
put the
didn't you
court-
cover all your bases after you saw that? Why did you think you could just limit it down?
Because a natural reading of her motion does not lend itself to a reading that there's 2 searches. There's one search.
But there was
That's exactly,
But there were.
that's exactly what the court thought, that there was only one, and it was a search pursuant to a warrant, when in reality, you were there way before you got a warrant.
Without searching. So I
Well-
think that lends itself to
But you were in. You were in the premises, and you needed some authority to get in there before the warrant. Whether it's exigent circumstances or her consent, you needed authority to get in.
So I think that actually lends itself to why this claim should not be reached in the interest of justice, because remanding for a hearing would just reveal what the trial record already revealed, which is that they went in just to freeze the premises. They did not do a search. They did a protective sweep, and then they waited until the search warrant was obtained before
Well,
they started
that's no
searching.
reason to deny people a hearing. Maybe you'll prevail at a hearing, but that doesn't mean they're not entitled to one, right?
I think that lends itself.
Let's hear from your, that was really rhetorical. All right, I'll withdraw it. All right, let's hear from your adversary on rebuttal. Thank you.
Thank you.
Again, a complicated case.
Yeah.
Well, thank you for your questions and your engagement, considering the hour especially. Go ahead.
Can you address, were there any exigent circumstances in this situation?
Were there?
Yes.
No, Your Honor.
Why not?
So the Calderones were arrested outside. The police then waited 20 minutes to knock on Mrs. Esperanza's door. Having received no answer at the door, they then waited 15 more minutes for uniformed patrol officers to arrive. And then those officers waited at the door for several minutes longer while speaking to Mrs. Esperanza. So I think exigent circumstances, apart from being unpreserved, is beside the point.
But
I'm sorry.
I'm sorry, I just have a question, because my recollection of the record is that the officers heard a toilet flushing, for example.
Yes, Your Honor.
Wouldn't that create maybe exigent circumstances because they were concerned that drugs were being flushed down the toilet? And as I recall, her hands were wet as well, or at least that's what there was testimony with respect to that.
Sure. So one officer recalled this. The other officer who testified did not recall this. But if it was truly so suspicious, why wait for her to open the door? I'll wait till you finish flushing your drugs or doing whatever you're doing, and then I'll enter? That doesn't make any sense under the exigent circumstances doctrine. But regardless, these issues need to be litigated at a hearing below. Whether there was exigent circumstances, whether we can deem the initial entry a protective sweep or a search, whether the warrant was an untainted independent source for the evidence, these are all questions that need to be addressed at a hearing.
Anything further? Thank you. Thank you both. Interesting argument.
Thank you so much. Have a good night.
You too.